Good morning, true crime minions and murder buffs. So listen, yesterday, I don't think I've recovered yet from yesterday. I really don't. I don't know many that have, actually. It definitely did not go, I think, the way anyone expected, including the defense. Now, I realize that out on the socials, there are many who think the defense just really had a bang up of a day. I don't really think being accused of witness intimidation to the FBI is actually a good look. I just, I don't know. Yeah. Um, he thought the gotcha, my favorite part is when Alan Jackson thought he was going to get her, Miss Devers, on the issue of attorneys can't file perjury on you. Attorneys can't do that. She said, no, but that's why I talked to the FBI about it. you know, that look changed. Like he was all like cat and mouse, like he had this big grin like on his face, like he was ready to go in for the kill. It changed immediately. And he says, oh, really? Did you? And then he starts talking about a report, and she starts hammering off evidence she has to prove this claim, which I'm sure he doesn't want anybody to get a copy of and bring into evidence, by the way. Oh, well, just to shut him down. Now, I will admit that some of her comments were unprofessional and she was very hostile unnecessarily. Um, they made it look like being called into the office was like some special occasion kind of thing, but she was worried about the testimony and probably may have been even the one who asked for that meeting. That didn't really come out. Um, Once she got subpoenaed for a comment, I don't think it's unreasonable for anybody to talk to her about it, especially if she had concerns, which she did, because her testimony was going to be twisted. She had already recanted it. People make mistakes. She may have saw Brian Higgins and the other officer in the Sally Port at another time on another case about something totally different. Absolutely, that could be true. Two things could be true at once. But when she realized that her shift was over and she left at 3:45, and Karen Reed's vehicle wasn't even there yet. I think I think the fact that this testimony was not brought in trial one speaks volumes. And I also think bringing it in on trial two speaks volumes also. To me, taking that kind of risk really leans towards a bit of desperation on the part of the defense. I really can't look at it any other way. Not a lawyer. What do I know? For all I know, it's the best legal move ever, and it's standard. Although I've never seen it. Um, I do see lawyers taking chances on risky witnesses that they know or could not come out the best for them, with the hope that they can turn it to mean something else to the jury, which I'm sure was Alan Jackson's egocentric circus style of lawyering's approach. I think he actually thought it was going to be represented as the big blue cover up. He just looked like the big blue meanie to me. And he painted his whole team with the same brush, unfortunately. Uh, and that's confirmed by the look on David Yannetti's face when the testimony happened. He looked straight at Alan Jackson, like dumbfounded. It was interesting. It was interesting. I'll say that. Anyway, thank you very much for the sticker, Shill. Good morning, Liam. Good morning, Book Lover and Couch. It's good to see everybody here. Hello, Maggie. I hope everybody is having a good morning. Yep, talking about Ms. Devers, Officer Kelly Devers. Thank you for the ordering. Talking about Officer Devers from yesterday. And I was so afraid to mispronounce her name, I'll be honest. I went back and listened to her say it to make sure, because she was quite annoyed at the way Alan Jackson was saying it. Are you talking about Dr. Marie Russell? being the first real witness, real expert witness. I find that like definitely something that certain elements of the socials would say, or totally ignoring everybody else that testified. But here's the thing, I cannot say that she's not qualified. She's a very experienced physician. She used to be a police officer. She is a forensic pathology, like she's actually done forensic pathology. Like, so she is very uniquely qualified. Well, she's never testified about a dog bite before, and she's only offered opinion that doesn't tie into any physical evidence whatsoever. None. No saliva, no puncture wound, no dog hairs, no tracks, no witnesses of a dog in the area, no pee in the snow, no poop nearby. What do you want from me? Like, I need more than just coming to the stand and saying, I got this. I'm the best at this. I know what I'm doing. And I say it's a dog bite. Because basically, when you look at the testimony, that's exactly all she's got. That's exactly all she said. Liam, you can't even find. I mean, I know they entered into evidence those two papers. I do believe they said that yesterday, but I can't find any listing of it. I think that's what you asked when you tagged me up here. If they've posted on the court site, if it's been updated, no. And I'm not even sure, because all I can see is the summation. I can't get any of the documents or anything like that. It's like it's really difficult. But when I look at it, I can only see like what documents have been posted and stuff like that. And there's not been anything clarifying those actually papers that she wrote. Hmm. She also seems to have oversold her qualifications as the only person who can identify a dog bite. Well, that became evidence on cross, didn't it? Because this is where Hank Brennan actually excels. Although he's an excellent prosecutor, he's laying out a very good case. His real talent is in defense, which makes him a killer when it comes to cross, even more so than the bullying Alan Jackson. I would say going toe to toe, Hank Brennan might have a little bit of an edge in being personable to the witnesses. Alan Jackson has a little bit of an edge because he's willing to just go beyond the boundaries with how he does stuff. Let's just put it that way. But I would say in that cross, it became very evident that being the only person that ever testified, like this is the only case she's ever testified in it. She had to admit that a dog trainer or anybody else could be able to do it too, and actually would say that she would prefer they didn't. And oh, by the way, the other expert witness that the defense plans on bringing is a dog trainer. And so, actually, pre testimony, which Hank Brennan has done before the witness even testifies, he's dismantling their credibility, just like he did with Disorno. He actually, when talking with his expert witnesses back and forth, actually discredited how Disorno was going to come in and talk about Welcher and Burgess's report, and actually went around the issues of it. You know, that's the thing about discovery. You get to learn what the expert witnesses, where they're going to be coming from. And a really good attorney prepares for it, molds it into his cross ahead of time. Because then when it comes up, it's not such a big impact to the jury. Just like the Proctor text. How many do you guys, I'm curious, what kind of impact do you think the Proctor text had on the jury? Besides the fact that some officer's an asshole, which he was, totally wrong, unprofessional. I thought it very odd that they entered the text into evidence but never had them read. The cross-examination of Hank Brennan read those into text, into the evidence in front of the jury. I thought that was really weird. I know, right, Maggie? I don't know if we're just desensitized to it or not, because we've heard it before, like, so I was thinking. Exactly, Liam. She wasn't prepared to do a bite analysis, which includes actual examples. Then she is just going on a gut feeling. Exactly. She's just saying, hey, you got it. She's like, trust me, bro. Trust me. I got this. And I'm just not about it. Like, I need more. I mean, she has obviously got a lot of medical experience, and she's very talented, intelligent physician, diagnostician, working in the ER that long, has some police experience, does pathology, forensic looking at things, that takes a lot. And I'm not going to say that she's not gifted in all those areas. She obviously is. But you need more than coming on here and saying, hey, I got this. I'm so like, I can do it. I'm it. But you need something to tie it into. At least for me. I mean, but lucky for them, I'm not on the jury. Really. I can see why people see them as dog bites. As I pointed out to you a while back, there's definitely areas which are similar to bites, which I have seen and had. Yes, sure. And you've seen them up close and personally, not just a photograph. And I'm sure there was some depth to them, wasn't there? Like the pattern could exist. Doesn't make it so. There's no puncture whatsoever, which is why Hank Brennan concentrated on the difference between a police dog and a regular dog. The dog they're blaming on this is a regular dog, which would not know how to hold back a bite like police dogs are trained to do. So there's no lawsuits and stuff like that. Like they are trained to subdue with the pressure and not do a puncture. So unless it's a canine police dog, which I'm not sure that that's what they're actually referring to, the defense has not said so, nor have they provided anything that indicates there was a canine police dog anywhere. So, it's pretty interesting, because they're not saying how these dog bites happened. They're not saying when they could have happened. For all we know, they happened during the day, and he just he went to a dog training thing in 2 days ago and got those injuries ahead of time. For all we know, I don't know, because basically the plausibility of it, I might as well be making up scenarios like that to go with it. If those are dog bites, then how, when, and they don't cause the death, and they don't really indicate anything else. They still don't go and do anything about the timeline. Am I wrong, people? Does it touch any of the evidence? If they are dog bites, does it touch any of the other evidence here? As far as the timeline, as far as the fact that Karen and John were in a Lexus, and within 60 seconds of that, he gets out of the car, she backs up, he never moves again. How do you get rid of that timeline with a witness that just says that those injuries might be a dog bite? How do you get rid of the taillight pieces that are all in his clothes? How do you get rid of the DNA in the hair on the vehicle? I mean, really, seriously, how do you get rid of all of that with somebody who says, I recognize a dog bite when I see it? I don't know. I don't know. Maybe I'm just making more of it. I know I'm being a little bit snarky, but it just irks me. They just they could just say it. They don't have to show anything to go with it. But it also, like, reasonable doubt has to actually be reasonable, and just saying something doesn't make it so. Just saying it doesn't really mean reasonable doubt. And I hope everybody gets a good lesson on that when they explain reasonable doubt in the jury instructions. Um, Proctor came in as a furry and we bit him. I more likely believe that than what else they've been selling. I don't see how it changes her charges either, Maggie. I get it.
All persons having anything to do before the
Here
Honorable
we are.
Beverly Cannone, the Justice of the Superior Court, hold an indebtum within and for the County of Norfolk. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is in session. Please be seated.
Good morning, counsel. Good morning, Ms. Reed. Good morning, jurors. I have to ask you those same 3 questions. Were you all able to follow my instructions and refrain from discussing this case with anyone since we left here yesterday? Everyone said yes or nodded affirmatively. Were you also able to follow the instructions and refrain from doing any independent research or investigation into this case? Everyone said yes or nodded affirmatively.
There's the volume's better now. Hopefully that's better.
See, hear, or read anything about the case since we left yesterday? Everyone said no or should. Does Dr. Russell?
Oh, shoot. Okay, I'm trying to get rid of the ball.
Brennan,
Hold on
you
one
can
second.
set up if you want to.
Hold on one second.
Everyone said no or should. Does Dr. Russell in the back there?
There we go. All nice and pretty.
Brennan, you can set up if you want to.
Oh, just as a reminder, we're going to do objections through the end of Dr. Russell's testimony to see about my bet with Maye, with Mr. Waffle.
Doctor, I'll remind you, you're still under oath. Thank you.
Thank you.
Good morning, Dr. Russell.
Good morning, Your Honor.
Yeah.
Yes.
Good morning, Doctor.
Good morning, Mr. Brennan.
I had asked you yesterday if your opinions regarding the wounds on Mr. O'Keefe's arm changed between when you testified last year and then the more recent hearings that we've had over the past 4 or 5 months. Do you remember that question?
Yes.
And when I asked you that question, I asked if you had help with your report, and you told us that there was a woman who helped you with your report.
I told you that there was someone who helped me or made suggestions in organizing the report, having certain sentences placed in certain categories.
When I asked you about the identity, the person who actually helped you, I asked you if it was one of the attorneys, and you had said no.
That is correct.
May I approach, Your Honor?
Yes.
Uh-oh. That doesn't sound good.
May I ask a question?
Yes.
Thank you. You had testified in December 22nd, 2024 in this case?
I believe it was that date, yes.
And when you testified back in December of 2024, do you remember I asked you who it was that had assisted you with your report?
I don't remember that specifically.
Well, I'm going to show you a page from the testimony. This is from the hearing. And I asked you, line 21, page 207, did anybody help you write this report? And what did you say?
I wrote the report.
If you could finish, please.
I had some help with some minor edits, rearranging, some paragraphs or whatsoever, but putting things in the right category.
Then I said, okay. And you answered.
No, I wrote the report.
And then finally I asked, who helped you with your report? What did you tell us?
I said Mr. Alessi.
And Mr. Alessi, is that gentleman the attorney who asked questions on direct examination?
Yes.
Okay. And so did Mr. Alessi help you with your report?
What I recall is we discussed the report, but I recall that it was someone else that actually helped me rearrange the report. That's my memory right now.
Is your memory different now than it was last December?
Well, I don't think so, but you have something in writing.
Do you think you would have testified to that if it was inaccurate?
Mr. Alessi did not help write the report. He may have helped organize and make a suggestion about what is training versus what is experience, but he did not help me write the report.
Did you have any help trying to describe methodology?
No.
You had any help talking about differential diagnosis?
No, I'm very familiar with differential
And
diagnosis.
so after that report was written, is there any reason why some of your opinions have changed?
I don't believe my opinions have changed.
When you testified at the hearing last year, June 21st, 2024, did you express that you couldn't say with 100% certainty what type of animal, in your opinion, caused those wounds?
100% certainty, that is absolutely correct. And I'd like to see that, but yes, that's my recollection.
If it's your recollection, I'm happy to show you what
Yes,
you
please.
testified to. You want to
Yes.
see it again?
Yes.
Okay. By the way, between last night and today, did you get any advice from anybody suggesting you should ask for a transcript when I ask you a question? Did that advice come your way?
That's my general advice from previous times.
Well, did you have any advice last night about that?
Yes.
Who told you last night that you should always ask for a transcript when I'm asking you questions?
Well, I think it was just Mr. Alessi.
So did you and Mr. Alessi, you know there's a sequestration order, don't you?
Yes.
A sequestration order that you're not supposed to discuss the case at all with anybody?
Well, we
during the
didn't discuss specifics.
Do you know that the sequestration order mandates that you not discuss anything about the case from when you start your testimony until you end your testimony? You know that, right?
I understand that there is a sequestration order.
Do you understand the sequestration order mandates that you're not supposed to speak to people, including the attorneys, about this case overnight? Did you understand that?
There were no specifics discussed.
Or did you understand that you weren't supposed to, is what I'm asking? Did you know that's a violation of the sequestration
No, I did
order
not.
to speak to the attorneys overnight?
I did not know that that particular conversation would be a violation.
So did you meet with Attorney Alessi last night?
No.
How was it that you had a conversation with him?
Actually, it might have been in the vehicle.
You drove together?
Yes.
So did you commute to and from court together with Attorney Alessi?
There's a driver.
Okay, who else is in the car when you left court yesterday?
The driver.
When you-
No, I wasn't with him yesterday. No. Not in the car yesterday. No.
Well, you just said that you spoke to Attorney Alessi yesterday. And I'm trying to figure out, when was it that you were having conversations with Mr. Alessi relative to the sequestration order that you're under?
This morning, riding to court
Okay, so you and Attorney Alessi drove to court?
with the limo driver. Yes.
Well, who was in the limo with you and Attorney Alessi on the way to court today?
That was just us.
Just you two?
Yeah.
What else did you both talk about other than that you should ask for a transcript every time I ask you a question?
That's what we talked about specific to this case.
Was it a long conversation?
No, not at all.
The entire ride here, there must be more you spoke about other than just a sequestration order.
We did. We spoke about Boston, how I love Boston, area. We spoke about New York. We spoke about other things. And in fact, I have to say that even on the ride home, back to the hotel yesterday with others in the car, nobody spoke about the case.
But I'm talking about this morning when you did speak about the case. What else? Not about the Red
That's-
Sox or the weather. What else did you talk to Attorney Alessi about this morning, other than you should ask for a transcript every time I ask you a question?
We talked about what I did last night.
About this case?
No,
I'm sorry, but I'm asking about this case.
that was it.
I want to know what all the discussions were between you and this attorney today or last night about this case.
Just that I should ask for a transcript.
Well, there must have been some there must have been some context. He didn't just turn to you talking about the weather and say, hey, you should ask for a transcript. You must have been talking about something.
He also generally, not today, but generally says, be honest. Always be honest.
Fantastic. But this morning about your testimony, what did he tell you? Did he tell you this morning you should be honest?
Not this morning.
Okay. Does anybody need to remind you to be honest when you testify?
No,
Okay. What else did he tell? How did it come up? Hey, by the way, ask
I-
for transcripts.
I don't even know how it came up. I didn't put much significance to it.
Well, it was just moments ago it happened because you just at the court. You can't remember the context of the sage advice of Attorney Alessi?
No.
Do you have any memory issues?
No.
May I approach?
Yes.
Transcript. Since you've asked for the transcript, I have it for you. Dr. Russell, this is June 21st, 2024. I had asked you whether you expressed that you couldn't say with 100% certainty. You agreed with my answer, so there's no need to try to refresh your memory, but I'm going to show it to you because you asked. Take a look at line 16. Is that now consistent with the questions I asked you and the answer that you gave, that you were less than, you couldn't be 100% certain?
That looks consistent.
You want more time with the transcript?
No.
Has anybody else talked to you about your testimony today overnight, Dr. Russell?
No.
When you testified last year, same transcript that we just looked at, do you remember when you gave your opinion to a reasonable degree of medical certainty, you said that you thought the wounds were from an animal, possibly a large dog?
On that same date,
Yes,
may I see the
of
transcript?
course. Pursuant to Attorney Alessi's advice, let me approach.
Objection, Your Honor.
I'm going to strike that, disregard that, Joyce.
May I approach?
Yes. What page you want us to?
23. June 21st, 2024, Doctor.
June 20.
Page 23, line 14. Will you ask the question based on everything we've discussed today? Is it your opinion based on a reasonable degree of medical certainty these injuries were from an animal attack, possibly a large dog? What did you say?
I said yes.
Thank you. Have that back.
Yes, you may.
Okay, thank you. When you gave your opinion, not this year, last year, you agreed when you were assessing the wound, you used the word or adopted the word possibly, didn't you?
Explain the context of it,
Sure.
that sentence?
Sure. Go right ahead.
No, you. I'm sorry.
Okay.
I'm sorry. Please
When
rephrase
you-
the question.
When you were asked about your opinion last year, not this year, last year, about whether, to a reasonable degree of medical certainty, the injuries were from an animal attack, possibly a large dog. You agreed with that characterization. A large animal, possibly a dog, didn't you?
Yes, an animal, possibly a large dog, last year, yes.
When you were on direct examination, there were tons of questions about this word methodology. Remember all those questions you were asked?
In June?
Yesterday.
Yesterday, okay, yes.
Yes. And when you were asked about methodology, was that an attempt to try to explain that you weren't just looking at an abrasion and guessing or eyeballing it? You were trying to suggest there's some type of scientific or medical process to give some type of certainty to your opinion?
That is the process I used.
When you talked about methodology yesterday, you talked about your experience in methodology with knife wounds and gunshot wounds, correct?
Yes,
But there was no methodology whatsoever regarding looking at a photograph and then identifying whether that is consistent with dog bites, is there?
I disagree.
When you described methodology, you were asked by attorney Alessi whether or not you've engaged in that methodology regarding dog bites. Did you agree that there is really no methodology regarding dog bites?
I disagree.
When you use the word methodology regarding dog bites, there isn't something specific you're looking at as if you were looking at a fingerprint. There are points of comparison. You don't do that, do you?
There are no specific points that are published by a organization, for instance, on how to determine something is a dog bite. However, I did use different methodologies, including what we talked about, the differential diagnosis, the pattern recognition. Pattern recognition, again, is so important in medicine. It's what pathologists use to diagnose tumors.
There
For
is no
instance.
standard. There is no recognized standard anywhere for methodology on how to identify a dog bite wound, is there?
There is no published standard from an organization that I am aware of.
So there is no source. There is no recognized community. There's no certification. There is no recognized method in identifying a superficial abrasion as a dog bite. Isn't that fair to say?
As in many conditions in the medical field, there are no certifications.
How about published standards? Is there any published standards whatsoever, any, regarding claims that a superficial abrasion is a dog bite? Are there any published standards by any organization?
No, but there would have to be thousands of published standards to identify the causes of the thousands of different types of abrasions. So no, there's no published standards.
No published standards. There is nowhere you can point to where the so-called methodology that you were telling the jury yesterday is a readily accepted standard in the dog bite community. You can't point to anywhere, can you?
There are peer review articles which list recommendations on how to determine something is from some wounds are from a dog. These are peer review articles written by esteemed physicians that have analyzed dog bites and have published these and have published an approach to identifying, particularly a forensic approach to identifying dog bites.
Let me ask you the question again, Dr. Russell. Can you point to one place where there is a readily accepted standard in the dog bite community for identifying dog bites? One article, one journal, one book. Can you point to any?
Well, I'm going to mention the articles I mentioned earlier. The article with the lead author of Dr. DeMunick and the article with the lead author of Dr. Pollack. And although they're not standards, they are recommendations.
I'm going to ask you the question one more time before I approach. Can you point to one place, one, where there is a readily accepted standard in the dog bite community for identifying dog bites?
No.
And so with no readily accepted standards in the dog bite community, no defined methodology, when you look at a photo like you do of John O'Keefe's arm, you're just eyeballing it based on your personal experience with dog bites, rather than relying on some type of scientific foundation that has been published and accepted in the community.
Objection, Your Honor.
I'm going to allow that.
Isn't that fair to say, Dr. Russell?
No, absolutely not. There are many, many conditions in medicine where there are no standards developed, and yet doctors make and nurse practitioners and the like make diagnoses all the time on these various medical conditions, and more importantly, they treat them because they require treatment. There are not published standards on every single of the 10,000 or more medical conditions that exist, including dog bites.
I'm not talking about a stuffy nose or a broken leg. We're talking about dog bites here. So let's focus on dog bites, if you would, if you can indulge me, doctor. Regarding dog bites, since there is no standard practice, there is no accepted methodology, and since there is no accepted and approved guidelines, you are essentially simply looking at a picture, a photograph, and just using your past experience with treating dog bites as the basis for your opinion. Isn't that fair to say?
I don't think so. I'm using my past experience, my strong interest in dog bites over 30 years, and the method and the articles that I read. The numerous articles I read, but the articles that have recommendations. I'm using all of that combined to come up with a methodology for determining that those are the result of a dog.
When you say coming up with a methodology, are you saying that you're creating your own methodology, that you're the person who has the standard and nobody else? Is that your position, Dr. Russell?
No, the phrasing was not good there. I use standard methodology of pattern recognition and differential diagnosis.
There is no standard in the medical community relative to differential diagnosis and pattern recognition as it relates to dog bites, not other areas of medicine, dog bites. There is no accepted methodology, is there?
That's true.
You mentioned that you have this strong interest in dog bites. Let me borrow a phrase. Do you think you had any confirmation bias when you got into this case?
I don't think so.
Well, you definitely wanted to be in this case. You weren't sought out. You sought the case.
That is incorrect.
And you said you had a strong interest in dogs, and that is one of the reasons you wanted to get involved in this case. Isn't that fair to say?
No, that's actually an unfair statement. I did not want to get involved. I wanted to offer my my knowledge and experience to help clarify issues. I did not want to become an expert witness in this case. And I used, again, as I do on just about every medical condition that I look at and every wound that I look at, I do a differential diagnosis. What else could this be? What else could have caused these scratches and abrasions and wounds? What else before I come to my conclusion?
On your ride over here today, were you instructed that when I ask a question, rather than answer it, give a long explanation about something else?
No. Oops.
I would like to
Sorry.
put up an exhibit of Mr. O'Keefe's arm, and I want to ask you some questions about it. You and I have had many conversations about Mr. O'Keefe's superficial scratches before, haven't we?
Yes.
And would you agree, looking at these, they are superficial abrasions? Do you agree with that characterization?
Yes.
When we last spoke, just for background, to remind ourselves, we broke these into separate parts so we could discuss them by number, just for the sense of clarity. And we discussed this as wound number 1. Do you remember that?
Grouping number 1, yes.
Number 2,
Yes.
number 3,
Yes.
4,
Yes.
5.
Which did you
I'm
call
sorry, this
4?
one,
4,
5.
5, 6, maybe.
Okay, so as we go through, I'm going to identify them by number. That wasn't done by anybody else. It was just during our discussion so we can have clarity. Is that fair?
Sustained.
Is it fair if I refer to this as 1, 2, 3, 4, 5, 6?
I think so.
Okay. When you testified on June 18th of 2024, last year, when you came in, you were asked questions before the actual hearing. You were asked questions about this particular superficial abrasion, weren't you?
I'd have to see the transcript. I believe
course.
so, but I'd have to see the
Do
transcript.
you remember when you were first giving opinion testimony about this specific abrasion, wound number 1? Do you remember you saying that you thought it was either teeth or nails?
I'd have to see the transcript again.
I will give you the transcript, and as I'm doing that, let me ask you, do you remember your testimony about what you actually said?
So do you remember your testimony?
For each specific day, no. I remember generally, but not for each specific day.
If you
I've
have
been
an
here many
opinion,
times.
I'm going to bring your transcript up to remind you, but if you have an opinion, it shouldn't change, right? It should always be the same?
Generally, yes.
Okay. So let me ask you before we talk about what you said at the beginning. What is this from? Teeth or nails?
It could be either, but I think that's from teeth.
So when you say they could be either, if you have a methodology and you have a certain standard where you can identify something based on a standard, there wouldn't be so much uncertainty, would there? You'd be able to look at this, consider the methodology, and either come to an opinion whether it was teeth, nails, or something totally different, right?
You know, Mr. Brennan, perhaps I didn't explain earlier, but the nail of a dog tends to be cone-shaped, conical in shape, and very similar to the nails that the canine teeth of dogs. So the shape and the fact that they come to a point makes some wounds indistinguishable.
Are you saying that nails of a dog are so similar to the teeth that you can't tell the difference between them when you're looking at a wound?
I'm saying that they can cause similar looking abrasions.
Are you able, as the premier expert in the United States on dog bites, able to tell the difference between teeth and claw nails of an animal when you're looking at a wound?
Individually, well, okay, that's a very interesting question. Sometimes it's difficult because they can have similar appearing wounds. So you have to look at the overall pattern in order to make some conclusions.
Well, when you first started testifying in this case, you never suggested you had to look at everything in totality. You were giving opinions regarding individual wounds. Isn't that fair to say?
No,
It wasn't until I began asking you questions and you had inconsistent answers that you've now changed from, rather than identifying individual wounds, now you're saying I can't identify individual wounds, but I can tell you in totality.
I disagree with that. I believe that in the very first time I testified, I mentioned that the overall pattern was important.
When you first testified, so today, before we get to your testimony, you're saying this could be either teeth or nails, but you think it's probably teeth.
Correct.
How probable? Do you think it's certainly teeth, to a reasonable degree of medical certainty? You're not sure? What is the value of your certainty or lack of certainty about what caused this wound?
Reasonable degree of medical certainty.
What is a reasonable degree of medical certainty? That what?
That those are caused by teeth.
Teeth. Okay. When you first testified, your position was it could have been teeth or nails. That is different than saying, to a reasonable degree of medical certainty, teeth, isn't it?
No, there is a small possibility that they could be caused by nails.
When you first testified, you didn't qualify it as a small possibility, did you?
I perhaps wasn't asked.
Well, you answered. Do you remember when you were asked about it and you answered? You talked about that it was a pattern close to the shoulder with parallel marks. Do you remember?
Do I remember what?
Saying that this is a pattern close to the shoulder, right? That they're superficial. You agree with that still?
Yes.
And did you say they were consistent with teeth and nail marks?
Yes.
Okay. Nails on a dog oftentimes or most times are horseshoe shaped, aren't they?
They're generally conical shape.
You don't think that nails on a dog in your studies have a horseshoe shape?
I think it depends on the grooming of the dog and if the nails were cut recently. But in general, they come to a point. They're at the, you know, at the end of the paw. They come to a point. And by the way, the paws can open and close. So the distance between the nails can vary depending on how that claw impacts the skin. So in many ways, they resemble the overall shape of canine teeth.
And so to get back to my question here, you're saying that this could have been caused by dog nails?
It's possible.
Do you know, or do you think that the teeth in a dog are different shapes and sizes?
Oh, yes. Depending on the tooth, there's different shapes and sizes. Absolutely.
When you testified the first time and you said that you thought it was teeth or nails, do you remember testifying a couple days later in front of a group of people and you again iterated that this could be teeth or claw marks? That was your testimony last year, teeth or claw marks, right?
I'm going to object to the characterization of that prior proceeding.
So just prior proceeding, folks, that's all that we need.
Did you testify at that prior proceeding last summer that this could have been teeth or claw marks?
I would need to see the transcript.
May I approach?
Yes.
When you first testified on June 18th, doctor, you were asked questions trying to identify what you thought that wound was. And this is your June 18th, 2024 testimony. On page 37, line 7, the questions begin, and you were asked what you thought they were. You can read any part you want, but line 7 might be a starting point.
Yes, I said that which are consistent with teeth marks. They also could be possibly consistent with nail marks.
Dr. Russell, I'm just going to ask you to keep your voice up, okay?
Okay.
Thank you. That was your first testimony last year, yes?
Yes.
And then did you testify a couple days later and again repeated the same opinion, teeth or nail marks?
May I see it?
I'm asking if you remember.
Yes, I remember testifying.
Do you remember after you worked on your report and submitted your report,
Yes.
after your consultations, do you remember changing that opinion regarding number one? Do you remember changing that opinion?
No.
Do you remember changing from either teeth or possibly claw marks to being very specific, claiming that it was definitely teeth marks?
No.
Are there different types of teeth in a dog?
Yes.
Okay. The pointy teeth, the big ones, those are called canines.
Correct.
And the smaller ones are incisors.
Correct.
There are 6 incisors in a healthy dog on the top and bottom between the canines.
Correct.
Did you, when you testified subsequently to the original proceedings, did you change your opinion from teeth or claw marks to specifically teeth and even more specifically canines?
Do you have a transcript?
I do, but I'm going to ask you the question. Do you remember changing your testimony from teeth or nails to being very certain that it was canines, not just teeth, canines that caused that wound?
I became more certain, yes.
You had never said that the canines caused these wounds before you filed the report, ever, did you?
I may not have, that's true.
And so after you did the report, you shifted from teeth and nails to canines. Do you remember that?
I don't think it's a shift.
No one would ever refer to a dog's nails as canines, would they?
No, I don't think so.
That would be inaccurate, wouldn't it?
Yes,
That would be a mistaken use of the word.
I believe so.
When you testified December 2024, you didn't say nails could have caused this wound. You didn't say generally teeth. You said canines.
I believe that, and that's true. I believe that canine teeth caused that wound.
Did you have any new information about photographs that would help you change your opinion from teeth and nails to canines?
Well, I had been challenged. I had testified several times. I reviewed the case several times and challenged. And each time I reviewed the case, I became more certain that these were from canine teeth.
So
And actually, there's other marks there, but these are from teeth.
you say more certain. You had never said canines before, ever, until that recent hearing. Isn't that true?
I said teeth.
Canines.
It doesn't matter. I said teeth.
Top,
Canines are some of the teeth.
upper or lower canines?
Upper.
And if it's upper canines, you testified previously that the point of entry would be here at the bottom and the dog would pull this way. That's what you testified to. Yes?
No, I believe you misunderstood then. The point of entry is up there. The first initial point of contact is there. And the dog pulled this way, or Mr. O'Keefe pulled his arm the opposite way.
Dr. Russell, you don't recall that you said that the bigger circles are the point of entry, the dog pulled this way, and then I asked you, how could a dog pull this way when the arc is like this? The dog's mouth would have to be in backwards. Remember that conversation we had?
Objection, Your Honor.
Before you allow.
Do you remember that conversation? You said that the point of entry would be the bigger circle pulled this way, and then I questioned, how could a dog's arc look like this if the teeth went that way?
No, I don't recall that
Do you
at
remember
all.
that conversation
No.
we had? Okay. And so inevitably, when you look at this part of the wound alone, have you expressed an opinion that you're unable on its own to be able to tell whether this was caused by a dog?
Which part of the wound?
Taking any of these alone, let's start with number one. Haven't you expressed an opinion that taking this alone, you would not be able to say that was from a dog bite?
That is correct. In and of themselves, they're not that specific or characteristic. However, as a group, they are highly characteristic of a dog
So if
injury.
Mr. O'Keefe's arm only had this wound and nothing else, by virtue of what you're telling us, you would not be able to offer an opinion that this was consistent with a dog bite.
That very first wound
Yes.
up there, closest, I agree. Yes.
In fact, you've testified about this very issue before. If this was the only wound on Mr. O'Keefe, number two, you would not be able to say that the injury is consistent with a dog bite.
Correct.
I'm going to go through all of these just so we're clear. Same thing with number three. You've provided opinions on this before. If you look at this wound alone, in isolation, you would not be able to say that it came from a dog bite.
Correct.
Four, pardon me. Yep. Four,
Mhm.
same. Looking at the wound alone, you would not be able to say it came from a dog bite.
Correct.
Same for 5 and same for 6.
Correct.
Now, when you testified before your recent testimony, you never had that qualification. When you came into court, you were saying that when you looked at these wounds individually, you were saying that you could identify it as a dog bite.
I disagree with that characterization.
Number 2, what caused this wound, Dr. Russell?
Number 2, I believe that was dog bite or scratch, but mostly I believe dog bite. And because there's a punctate, little tiny pinpoint almost lesion there and there, which could represent bottom teeth.
Okay, so you're using words like could, and we're talking about a reasonable degree of medical certainty. So when you look at this wound here, you said that you are sure or not sure what caused this wound.
I'm saying that individually, that wound, that's correct. I'm not sure individually what that wound was caused by. However, again, as I mentioned earlier, the overall pattern of wounds is what I am convinced of.
I want to go through each of these wounds separately so we understand what you actually recognize with your methodology and what you don't. So looking at wound number 2, based on whatever methodology you've been using, are there any signs, indicators, objective criteria you can look at and tell us this is or is not a dog bite based on this methodology you have?
There are some characteristics that are suggestive of a dog bite or dog claw, including the fact that there are parallel lesions, and many of these overall, by the way, parallel lesions are in the same general direction. So there are parallel lesions, and here they're associated with some punctate or point-like other abrasions right here. So they're consistent with being inflicted by a dog.
I appreciate you using some medical terms to describe this, but my question is more pointed. Is there anything about your methodology, something that stands out about these wounds, that you can say to a reasonable degree of medical certainty that these are consistent with a dog either biting or scratching?
These wounds all by themselves, not to a medical degree of certainty, no.
You said on this first wound, you thought this was from the canines. Those are the big upper teeth is what you're claiming, right?
Yes.
And you're saying today anyways, starts here at the bottom and goes up. Is that
No.
your position today?
That's not what I said. I said the
Okay.
exact opposite.
So it starts here and comes down.
Correct.
Okay. And these 2 scratches, they're linear, just like these are linear, aren't they?
Yes.
But you have a problem with these because if these are the canines, you see the spacing there?
Uh-huh.
This is nowhere close, is it?
I didn't say that these were caused by canines. And spacing also, there's reasons why the spacing could be different.
Well, we can talk about that in a second. Are you suggesting that these these 2 linear abrasions, just like 1 and 2, are you suggesting the canines caused these?
I don't know what caused those, which teeth caused those, or which nails caused those.
When you testified last year on June 18th, you said that this was either teeth or claws. Can you give us any development of your opinions, whether or not you think that is teeth or claws?
Excuse me? No, well, I couldn't hear because of the fan.
When you testified on June 18th, you said wound number 2, the top 2 linear abrasions, you believe were either teeth or claws. You've shared with us now you have improved your study and have new opinions. Do you have a clearer opinion whether this is teeth or claws?
Objection, Your Honor.
Sustained, ask it differently.
Do you have an opinion whether this is teeth or claws or not something totally different than a dog?
I believe they are teeth or claws caused.
When you testified at trial and in that hearing that they were teeth or claws, you changed that opinion as well at the most recent hearings, didn't you?
No, I'm going to object to the word that you used has been done before.
Mr. Brennan, word it differently.
Sorry?
Word it differently.
Did you testify at a more recent hearing that teeth made these, not teeth or claws, but teeth?
I may have, and I would like to see that.
May I
Can you
approach?
just hold 1 second? Could you please turn the fan off? Joyce, is it okay if we turn the fan off so we can hear better? Thank you very much, officer.
May I approach?
Yes.
From your December hearing, page 100, line 5, when you were asked about that second wound in December, and I asked whether you changed your opinion from teeth or claws to just teeth. Weren't you asked specifically about that on page 100, line 5?
Yes. But may I read it?
Sure, I'll read it with you.
Okay. I said, I'm not sure on the second set. So this is the set just above the elbow.
I'm not sure exactly what teeth made these. They could, one of them could, one set of these could be canine, one part of this, and then adjacent incisor tooth. But I'm not sure on the second set, so this is the set just above the elbow.
Yeah, I think the first part of that paragraph is talking about the first set
Yes.
up there close to the shoulder. And then the sentence, but I'm not sure on the second set. So this is the set that's just above the elbow. I said, I'm not sure.
And then, sorry.
Oh, go ahead.
Are you done?
Oh. Yeah, actually, I did make another comment. What is it? So, however, what is interesting and certain is that there's an upper set and a lower set. So this mark was an upper tooth. This is a lower tooth. What I was referring to is this mark here and that mark, and then this mark here and this mark here. So it appears that this is from upper and these are from lower. That's what I was referring to.
And so when you first described this wound as teeth or claws, at the most recent hearing, you had a certain opinion that this was teeth, didn't you?
Yes, I was leaning towards teeth. Correct.
Well, it didn't seem like you were leaning. You said these were from the upper teeth.
Yes.
You said it matter of factly, not with any qualification. Your claim at the last hearing is this was from teeth.
That's what I believed.
And today you're saying you don't know if these were teeth or claws.
Not with 100% certainty.
You didn't qualify 100% certainty. You were asked your opinion, Dr. Russell. You were
Yes.
asked, what do you think? And you didn't say without 100% certainty. Your claim, the first time you testified, teeth or claws. Recently, you said teeth, and now you're saying you're not sure.
No, I'm saying I believe that those marks are from teeth, but I'm not 100% certain.
Suffice to say, looking at wound 2 alone, you cannot say this was caused by a dog.
In and of itself, no.
What tooth do you think caused this wound?
I don't know.
Do you think this in any way could be caused by dog teeth if you're claiming that this is dog teeth?
Excuse me?
Do you think there's any way these two could be caused by dog teeth if you're saying that these two were caused by dog teeth?
Yes, it could be, but I don't know which teeth. And I don't know the extent of the bite, how much impact there was, and how much pressure, how much contact there was between the teeth and the skin.
The canines are the longer teeth in a dog's mouth, aren't they?
They are.
And when a dog bites, it's very common for the canines to puncture, isn't it?
It's common if there's enough force, and it's common that you might have two canines if the strike is perpendicular to the skin. But if you have a tangential strike, a partial strike where only part of the teeth impact, you'll get different configurations.
Look at the spacing,
Well,
Dr. Russell.
Did you say strike or strike?
Strike with a K.
Look at the spacing, Dr. Russell.
Mhm.
A dog causing these wounds, the canines are not going to have such a dramatic distance between them because dog canines don't move, do they?
They don't, and I'm not claiming that these two parallel stripes in this case, or abrasions here, I'm not claiming that those two were caused by canines.
You think a dog is going to leave a wound with linear abrasions using its incisors as opposed to its canines? Is that your opinion?
It's possible if that's the only part of the mouth or the jaw that actually touched the skin, if it didn't go back as far as the canines.
Did you ever look at the underside of Mr. O'Keefe's arm?
I did.
Posterior side?
Excuse me. Pictures, yes.
Yeah. And when you looked at the photographs of the posterior side of Mr. O'Keefe's arm, did you find anything conspicuously absent from underneath his arm?
Well, first of all, let me clarify. Part of this is the posterior aspect of the arm. So are you asking me, did I look at the underside of the arm, the fleshy part
That's
of the
exactly
arm?
what I'm asking. It's a question I've asked before. When you look at the other side of Mr. O'Keefe's arm, did you notice anything conspicuously absent?
Yes, there's an absence of wounds.
When a dog bites, I don't care if it's a law enforcement dog or a domestic dog, you know it's like a lever, a dog's mouth, isn't it?
It can be if both jaws strike the skin. However, there are many times when only the upper jaw strikes the skin.
The lower jaw is a lever, locks, and that's part of the clamping and pulling process of a dog, whether it's a law enforcement dog or a domestic dog. You know that, don't you?
I know that they are attached.
Your claim is that there's many, many different dog bites on Mr. O'Keefe's arm. Are you suggesting, to a reasonable degree of medical certainty, that these are a number of different dog strikes and coincidentally, every single one of them lacks any wound to the underside of his arm?
Yes,
Your claim is that a dog penetrated the sweater on the top, but the lower jaw did not leave any wounds?
I'm claiming that that's not what I'm claiming. No. As I mentioned earlier, these could be from lower jaw. Those right there.
You're saying could be.
Could be.
That's speculation. We're asking you for your medical opinions. Your medical opinions. Do you have any evidence that the dog's lower jaw, you said maybe upper, maybe, that the lower jaw, even just once in this whole event, penetrated Mr. O'Keefe's skin?
No, nothing penetrated the skin. There was no actual penetration of the skin. These are abrasions. But I believe that these small marks right here, punctate marks, may be the result of lower jaw impact.
Rather than deal in speculation and maybes, can you tell us to a reasonable degree of medical certainty whether or not this was caused by a tooth?
Yes, Your Honor.
We're going to strike the first part. Why don't you ask the other part?
Can you tell us to a reasonable degree of medical certainty whether this superficial abrasion, put that back up, please, was caused by a dog?
In and of itself, that part only, no.
Can you tell us anywhere on Mr. O'Keefe's arm to a reasonable degree of medical certainty where the lower jaw impacted Mr. O'Keefe to leave even a scratch?
Not with a reasonable degree of medical certainty on individual wounds.
And not just individual wounds, I'm talking specifically the lower jaw. Can you point to one wound, one abrasion on that arm where you can say to a reasonable degree of medical certainty the lower jaw caused any of those abrasions?
I believe there are several areas where there's impact from the lower jaw. However, I cannot say with reasonable degree of medical certainty that part only.
Let's look at number 3 to move along. When you first talked about these wounds, again, is it fair to say that you described that it could have either been teeth or claw?
I'd have to see it.
Okay, I'll bring it to you. You don't remember that testimony?
I remember, again, I've been here many times, so I want to be,
Well, you have the
Specific.
opinion today, and I'm getting the transcript for you, Dr. Russell.
thank
Do you
you.
have the opinion today that that those were either teeth or claws?
Yes.
What's your opinion today?
Well, I think that most likely they are from teeth marks.
Well, rather than most likely, we deal with reasonable degree of medical certainty. To a reasonable degree of medical certainty, can you give us an opinion regarding the cause of those marks?
Objection, Your Honor.
So I'll strike the comment.
Can you tell us to a reasonable degree of medical certainty whether these wounds were caused by teeth or claws?
Individually, no.
Did you ever change your mind about the source of these abrasions?
Can you be more
Did
specific?
you ever claim that any of these abrasions were from upper or lower teeth?
I don't recall changing my mind.
You don't recall if you've ever said that? Let's separate these bottom wounds. Do you have an opinion to a reasonable degree of medical certainty whether these were caused by teeth or claws?
I have an opinion.
To a reasonable degree of medical certainty?
No.
Do you have an opinion to a reasonable degree of medical certainty whether these were caused by either a dog teeth or dog claws?
I have an opinion.
To a reasonable degree of medical certainty?
Individually, no.
The one near the wrist, you had testified yesterday, there's lines in what you believe to be an arc, correct?
Yes, they have a general overall appearance of an arc.
If there's an arc and there's 2 linear abrasions on the outside borders, wouldn't these necessarily have to be the outside borders from canine teeth?
Not necessarily.
They're longer than the middle ones, aren't they?
The abrasions are, but doesn't mean the teeth are.
If this was an arc, like you claimed, you think different teeth other than the canines could have caused the outside scratches?
It's possible.
And you do note the distance between the top and bottom of those wounds compared to the distance in number 2 and the distance in number 1.
I see the difference, yes.
And you have to concede, Dr. Russell, that the same set of teeth, the same canines, could not reasonably have caused this wound, and this wound, given the distance between the inside and outside.
First of all, I'm not certain that these are all canines, as I mentioned earlier. Secondly, you have to take into account that skin is elastic. It bends. It depresses. So you could have 2 prongs, for instance, of a pitchfork, for instance, just as an example, impact the skin in different places, and the measurement between the two can be slightly different depending on the elasticity of the skin and the underlying structures.
This is not a slight difference, Dr. Russell, is it? The distances?
Again,
Objection, Your Honor.
So there was a question with that, so I'm gonna let that.
Again, Dr. Russell, the distance here, it's not insignificant, is it?
Mr. Brennan, I already mentioned that I did not think that these were caused by two canine teeth.
And these, the distance between these two, have you measured them?
I approximated them, yes.
What
And
did you come up with?
visually, and I can see that there's a difference.
What was your measurement for this one?
I think about 4 centimeters, and this was a little bit more.
Did you note that in the report? Did you
No, I
actually
did not.
measure them, did you actually take out a ruler, measure them, and document them as you studied these wounds? Did you go through that process during your methodology?
No, because this is an image, and there's no scale in this image as to how far away different points are. So my own measurement would not be accurate because there's no scale in the picture.
Why did you go through the process of measuring them if you're now saying that it's inaccurate after I asked you if you memorialized it? Why would you even do it if you're now saying it was inaccurate?
It was an approximate measurement in my mind.
In your mind?
Yeah.
Okay, but you never put it on a piece of paper or report, notes?
That's correct.
Why would you even go through the process if you're looking at it and your explanation is it's only a photo, I wouldn't be able to tell? Why would you even try to?
I think probably everybody in this room has already done the same thing.
And if anybody in this room did the same thing, it would be quite obvious, doctor, that the gaps between 1, 2, and 5 are dramatically different from each other, aren't they?
They are. However, I'm not saying the same exact teeth caused those marks.
When you testified yesterday, you used the term differential diagnosis. I want to ask you a lot of questions about differential diagnosis. Do you remember using that term?
Yes.
And differential diagnosis was really just a way for you to try to get your opinion to the jury that these injuries were not consistent with the car accident. That's what a fancy way of doing it is, right?
No, it was a method I used.
Differential diagnosis, you're claiming that you can say this is not from a car accident or a car collision. That's what you're trying to say, aren't you?
That was the result of my differential diagnosis and my pattern recognition
So if
methodologies.
if you're going to exclude a cause of the injury, in this case, a collision, you have to know a little bit about collisions, don't you?
Yes. I don't know how to answer that.
Well, try.
Can you be more specific?
If you're going to say that these superficial abrasions could not have been caused by a car collision, you kind of have to understand a little bit about the mechanics of a car collision, don't you?
Actually, I disagree. However, I've treated thousands of victims of motor vehicle accidents and have seen the wound patterns that they come into the emergency room with. And that forms a basis for me.
Do you really think?
I'm sorry, please.
Did you finish that answer, Dr.?
No.
Did I cut you off?
I believe so.
Oh, I'm sorry. Please continue.
No, and the thousands of victims of motor vehicle accidents, I've looked at their wounds, I've treated their wounds, cleaned their wounds, touched their wounds, and that is what I use as a basis, part of my basis to determine that these were not caused or not consistent with a motor vehicle accident.
When you first gave that opinion that it wasn't consistent with the motor vehicle accident, it's fair to say you didn't have a lot of information at that time when you first came in and said that, correct?
Specific to this case?
Yes. Yes.
I didn't have a lot of information, that's correct.
Okay. And so in order to rule out a collision causing these wounds, let me ask you, are you an accident reconstruction expert?
Reconstruction? No.
Did you ever go to any academy for training to receive any type of degree or certificates in car collisions?
Actually, I did receive a certificate in hit and run accident investigation from the Massachusetts Criminal Justice Training Council when I was a police officer.
Do you agree that what training you did have was rudimentary?
It probably was, yes.
Well, not probably. You've used that word before. Wouldn't you say that any training you have had has been rudimentary?
In terms of accident and
Yes.
investigation, yes.
Have you ever testified as an expert anywhere in accident reconstruction?
No.
Do you know what ACTAR is?
ACTAR?
Yes.
No.
It's a certification group for collision specialists, accident reconstructionists. Is it fair to say that you're not ACTAR qualified?
Objection, Your Honor.
I'm going to sustain the objection.
Are you ACTAR qualified?
No, and I don't know any physicians that are.
Have you ever gone to a scene of a car collision and done an investigation and written a report and reached a conclusion about the cause of the car collision and the injuries that were related to that car collision?
No, that's outside my scope.
It's beyond your expertise.
Beyond the expertise of a physician, yes.
Right. Yet, yesterday, you offered the jury your opinion that these wounds were not consistent with a car collision. Did you offer that opinion yesterday?
Wounds are in my area of expertise. So yes, I am very comfortable talking about wounds from a variety of sources, including motor vehicle accidents.
I'm sorry, I didn't want the siren to interrupt you.
Okay. Yeah, wounds are definitely within my area of expertise.
When you considered your opinion to this jury that this was not caused by a car collision, do you know what type of vehicle is in question?
Yes.
Have you ever studied the vehicle to look at the make, model, the height of different things like the bumper, perhaps the taillight? Have you ever studied that in this case?
I'm aware of some of those factors.
Have you
Yes.
studied that before you gave this
Studied.
opinion? Yes. Did you go and actually look at the photos, do any measurements before you came up with this opinion?
Not before I came up with the opinion, no.
Did you ever look at the damage to the rear taillight of the defendant's vehicle and see if it was in similar or the same height of Mr. O'Keefe if he was standing up? Did you ever do that?
I have looked at
And
photographs.
when you looked at the photos, did you see that a 6'1" man like Mr. O'Keefe, if he stood, his elbow would be the exact height of Miss Reed's broken taillight? Did you notice that?
I noticed that there was a similar, that the height would be similar. The height of the elbow and the taillight, yes.
Did you look at photographs of Miss Reed's broken taillight and see if where the break was corresponded closely or directly to the same height as Mr. O'Keefe's elbow and forearm?
I did.
And did you see that it matched up height-wise perfectly?
Close, yes.
You have really no, respectfully, comprehension about the details of the car collision in this case, do you?
I have some understanding of the allegations of a possible collision.
Do you know how slowly or fastly Miss Reed's Lexus was traveling on January 29, 2022 at about 12:32 a.m., right around the time that you think these wounds happened?
I have some knowledge of the alleged speed at the time of the alleged collision.
Do you have any knowledge about the surroundings, the outside, whether the ground was soft or frozen?
I understand that there was snow on the ground.
How much snow do you understand was on the ground when Mr. O'Keefe's body first landed on that ground?
Several inches.
Where did you get the information that there were several inches of snow on the ground when Mr. O'Keefe landed?
You asked me when?
Where did you get that information from?
A report that I read.
Have you ever seen the videos or the reports that when Mr. O'Keefe was moved from the ground, there was grass and dirt under him?
Yes, I saw a picture.
Okay. Not 2 inches of snow. The ground, the cold, hard ground. Did you see anything that said that?
Yes, I saw an area of grass in the picture.
Have you ever looked at Mr. O'Keefe's pants to see if there was any dirt or grass stains on the back of them?
I've seen pictures.
Did you realize when you were forming your opinions about the source or the genesis or the cause of these abrasions, did you look at his pants and study whether or not he landed on snow or landed on the hard ground?
I did not see any evidence of grass on the pants.
Did you ever actually look at
I
the
don't.
pants?
I don't know if I looked at the pants.
So when you
to tell
say you
the
didn't
truth.
see any evidence, are you saying you didn't look, or you looked and you didn't see anything?
I looked at pictures of the clothing that was available at the hospital.
Did you look at anything about the pants, photographs, the actual pants themselves? Did you look at them?
I looked at the pictures that were available at the hospital of his clothing that was on the floor.
Were part of the photographs that were available for your review and your conclusions of differential diagnosis, was part of that evidence photographs of the back of his pants?
I don't recall.
If you're going to make an opinion about something outside your expertise, that this was not consistent with a collision, wouldn't you want to see as much information as possible?
So let's, we'll come to that.
Oh, this is getting contentious. I do think that he's going a bit far. He's going to lose the jury if he keeps this up. I am usually all for trying to impeach the testimony, but he needs to stay on track. It's getting a little off. Karen, if Karen asks, did we ever find out how big this dog was? The dog the defense keeps referring to is Chloe, which is a German Shepherd, a full-size, rather large German Shepherd that is owned by the Alberts. They've never actually said that the dog, like the experts aren't saying that that's the dog that caused the injuries. It is alluded in the conspiracy theory of the defense out there that the dog attacked John O'Keefe inside the house. And he was beat up. It was part of the whole thing. Exactly, Liam. It's only trained dogs that attack one specific area of the arm routinely, wouldn't you say, Liam? I mean, if it's only going to be injuries where they are on him, that would be defensive. He has his arm in front of him. The dog is going for the upper part. That's a trained dog, right? Or am I making too much of an assumption? Hands would be damaged, exactly. Right. And you've pretty much got that experience. I mean, it's just for me, I'm coming from it from a common sense kind of angle. But you know how they are. Oh boy. Oh boy. But that's our first sidebar of the day anyway. And so far with this testimony, we're up to, let's see, 11 plus 9. We're at 20 defense objections to 30 for the prosecution from yesterday. Defense has a good opportunity here to catch up before the end of her testimony. And perhaps I will owe 10,000 oboe bucks to to Waffle. Y'all are keeping me honest though on it. I do think that Hank needs to stay on track here and not be snake. That nasty comment about Alessi, that was just not nice. That was bad legal manners. You guys have a bingo card. The Commonwealth is guilty of bad legal manners with that comment. Definitely. Yeah, Exactly, Liam. There's definitely some training involved there. I agree. He said that many trainers get the dog to bite, a dog to either attack just the left arm or to grab a point of opportunity on either arm, right? And it's usually, for it to be like that, his arm had to be in front of him. Like, you know what I mean? Like, um, he would have been pulling his arm away from the dog. I mean, I'm not going to say it's not plausible, but with the timeline that we indicated, I don't think it's. I'm not going to say it's not possible, but it's not plausible because of the timeline. It's not. But I do hope that Mr. Brennan would just finish his impeachment and his credibility standard here. I thought when he stayed on track with the methodology, that was better. And he did a little bit of impeachment on her memory and what she was testifying to. And she's not changing her opinion. She is changing how she explains it. She is explaining how definite she is about things. And she adds stuff here and there. But her opinion that it's possibly an animal bite has stayed the same. She's just, excuse me, as Attorney Brennan has pointed out, she just has fluctuated back and forth in how she explains it and what terminology she's using and how definite or precise she is, how specific she is, which can be a problem. Especially when she had the help of the attorneys to make her report, where she got really specific. I mean, that should be an issue for the jury.
Dr. Russell, before you gave your opinion to this jury, suggesting that Mr. O'Keefe's wounds on his arm were not caused by an impact with a motor vehicle, did you go to the scene of 34 Fairview and look around in the corner of the yard?
I did not need to.
Did you?
No.
Did you look at photographs to see if you could identify the land, the dirt, whether it was flat and smooth or whether it was bumpy, whether there was rocks or debris in that area?
Yes.
And you went there and looked at it?
No. You asked me if I looked at photographs.
When you looked at photographs, did they show whether that ground had any bumps or divots or rocks?
It showed that there was a little bit of a hill in that area.
Could you tell from the photos, were they close enough so that you could see what the makeup of the ground was?
No, most of the ground was covered with snow.
Did you know that there were bushes right near the area where Mr. O'Keefe was found? Bushes with branches. Did you know that?
Not very close, no.
Did you see the bushes in the photographs near where Mr. O'Keefe lay?
Right where he laid, no.
How about next to him on the left? Did you see those bushes?
There was some other stuff there in the photograph, but the photographs I looked at were not of excellent quality.
Do you have any understanding or information you can share with us the angle of Mr. O'Keefe's body at the time of any impact with a motor vehicle?
I don't see any medical evidence that there was impact with the vehicle.
Do you know Mr. O'Keefe had other injuries other than just the superficial abrasions on his arm?
Yes, but no significant injuries below the neck.
How about on the head? Was there a significant injury?
Oh, yes.
When you considered excluding car collision as a source of those wounds, did you consider in your history that you've seen, or have you seen, let me strike that, have you seen in your history multiple victims of a car collision where
Many.
they were
Sorry.
hit by the same car?
Probably, but I can't recall a specific case.
Would you agree with me if a car ran into a group of people and caused a number of injuries, those injuries to different people could vary wildly from one to another?
Yes,
Even if the car was going at the same speed and ran into a group of people, those injuries could be totally dissimilar from one another, couldn't they?
yes,
Some person, unfortunately, could be killed if the car was going fast enough and hit them the right way. Yes?
yes,
Another person could have a less severe injury, maybe a broken bone.
yes,
Another person in the same exact collision could have scratches.
yes.
In fact, there are cases, I'm sure you've studied, where people have been hit by cars, thrown airborne, and had no wounds on them at all. Have you seen that?
Could you repeat that?
Are the instances that you have considered where a person is hit by an automobile, actually thrown, removed from the ground, thrown in the air, and gets up unscathed with no injury at all?
No significant injuries, correct.
So a car collision can cause wildly different injuries depending on many, many unpredictable factors. Isn't that fair to say?
Yes,
When a vehicle's involved, have you ever been involved in treating patients that received injuries from broken plastic or broken glass in a car?
yes, many times.
And when you've seen them, have those injuries differed on a person as far as cuts and abrasions from glass or broken plastic?
Yes,
When you were considering excluding car impact or collision as a source of Mr. O'Keefe's injuries, did you consider whether or not Mr. O'Keefe could have been struck on the side of the car in a clip type event rather than being run over?
yes, I considered multiple scenarios.
Had you, or do you agree that injuries from a side swipe or from a clip could be much, much different than a full rear or front impact being run over?
They could be.
Did you do any study in this case when you were thinking about excluding the car collision or impact as the source of Mr. O'Keefe's abrasions, about what his body posture was, how he may have hit a motor vehicle? Did you consider that?
I considered several scenarios,
And when you
several different positions.
And when you considered that, what did you conclude as far as Mr. O'Keefe's body movement at the time of any potential impact?
Oh, first of all, I didn't see any medical evidence that there was an impact. There were no significant injuries from the neck down, no fractures, no bruise, no internal injuries, no lacerated organs, no collections of fluid in the lung cavities, the abdominal cavity, no significant injuries from the neck down. And so, yes, I used that and tried to put that in a scenario of his various positions. What could he have been standing, kneeling, sitting, lying down on the ground? I did all that.
You were a police officer before you went to medical school, weren't you?
Yes,
You had arrived at scenes of many, many car collisions, hadn't you?
yes.
What is oftentimes left behind after a car collides with an object?
Debris.
Debris field, yes? Did you look at the debris field in this case?
No.
In the cases that you went to wherever you saw car collisions, some of the debris that you would find could be broken glass or broken plastic. Isn't that fair to say?
Yes.
And when you went to those scenes, you would often find broken glass or broken plastic in a debris field near where the victim was found or laying. Isn't that fair to say?
The debris field would be usually near the collision, if there was a collision impact.
And when you were considering excluding car impact or collision in this case, did you take a look at the entire debris field to determine how close or far it was from Mr. O'Keefe's body?
I couldn't tell on
Did you
the
ask any
photographs.
question? I'm sorry, please finish.
I couldn't tell from the photographs.
And before you came to your conclusions, did you ask anybody for any more information so that you could make a fair assessment of that information?
The injuries here were so characteristic that, and they were so parallel to one another that I couldn't even imagine pieces of glass or plastic or even metal lining up to cause those injuries, lining up in a certain fashion to cause those regular striations.
Rather than imagining, did you make any effort to actually seek information so you could identify and evaluate the debris field around Mr. O'Keefe's body that morning?
I did not.
Have you ever, as a police officer looking into car collisions, ever hear of the term knocked out of one's shoes?
Not as a police officer.
Have you ever heard of that as a medical expert?
I've heard of it as a civilian, yes. Not as a medical expert.
Can I have Exhibit 74B, please? In your study, before you gave an opinion excluding an impact or a collision as the cause of Mr. O'Keefe's abrasions on his arm, were you aware of this photograph where Mr. O'Keefe's sneaker was found on the side of the road?
I am aware that there was one shoe off, correct?
Were you aware that it was wedged right up against the curb? Were you aware of that?
I'm aware, I have been aware of that, yes.
And when you came to your conclusion that you offered that the injuries are not consistent with a impact or car collision, was this photograph part of your consideration?
No.
Could I have Exhibit 99D, please? In your study to give an ultimate opinion, where you suggest that a car collision or impact was not the source of Mr. O'Keefe's arm injuries, were you aware of this photograph of Mr. O'Keefe's hat found at the bottom of the snow in the corner of that yard?
No.
Do you see underneath that hat, there was not 2 inches of snow? It looks like dirt and grass.
Yes.
When you gave the opinion that he was on 2 inches of snow, would it be important to know whether or not he fell directly on the hard ground or on snow?
It could be important. However, it could be. If the ground was frozen, if it wasn't frozen, it could matter a little bit.
Exhibit 73, please. When you were reaching your conclusions, you said you considered some of the debris field. Did you see this photograph of a piece of taillight that matches the defendant's taillight of her SUV? Did you consider this piece of evidence that was found in the debris field?
Not specifically.
76A, please. Same question. Did you consider this piece of the debris field when you were coming to your conclusions that you offered us yesterday?
I considered that there would be several pieces of metal, plastic, or glass at the scene.
Did you consider this picture of plastic from the defendant's rear taillight found at that scene? Did you consider that before you gave your opinion to the jury?
No.
You can take that down, please. Would there be any significance in your study in the foundation of your opinion that a collision or impact did not cause Mr. O'Keefe's wounds on his arm? Was it important for you to determine whether or not the taillight to the defendant's Lexus was broken early that morning?
I think there needs to be more to the question.
Okay. When you were considering potential causes of injuries, did you know that the defendant's Lexus rear right taillight was broken in missing pieces?
Yes.
Was it important to time when that taillight was broken?
What do you mean by time?
You understand that Mr. O'Keefe was found on January 29th, 2022, yes?
Yes.
Early morning hours.
Yes.
when you were making your differential diagnosis, was it important for you to learn whether around that time the defendant's taillight was broken?
It was important to know. I still don't understand the question. I'm having a trouble
Okay,
understanding the
it's
question.
my fault. I'll try to ask it a different way. You were considering as much facts and information as you could to give a solid opinion in front of this jury, weren't you?
Yes,
And you ultimately have offered an opinion that the wounds to Mr. O'Keefe's arm are not consistent with an impact or a collision with a vehicle. Yes?
that's correct.
You know the vehicle in question in this case is the defendant's vehicle, her Lexus.
Yes,
And you learned that her right rear taillight was broken and missing pieces. Yes?
yes,
Did you want to know if there was any evidence depicting when that taillight was broken? And considering this conclusion,
yes,
did you know that there was video from 5:07 a.m. showing that the defendant's taillight was missing pieces?
Objection, Your Honor.
I'm going to allow that.
not at the time, but I expected that if there were a collision, that there would be pieces of the car, a car, involved. So it didn't really make any difference.
When you were trying to rule out a collision between Mr. O'Keefe and Miss Reed's vehicle did not cause these injuries, did you want to seek that information about the broken taillight and date and time?
A broken taillight in and of itself could not cause those injuries. There would have to be multiple projections from the vehicle that were lined up in certain pattern to give those parallel marks all in the same direction. So, that's why a broken taillight could not have done that.
So you, in your investigation, you did not want to know when that taillight was broken.
Oh, I did, but for information only.
Did you review the ring video from 5:07 a.m. at Meadows Ave?
Later on, later on in the, not initially when I had the initial records, but later on I did.
Did you have that information before or after you arrived at your opinion?
Oh, after.
So you had already arrived at your opinion, then you received new information, which was that ring video, correct?
And it confirms, yeah.
And then you received more information. Did you receive photographs from a dash cam during a wellness check showing the defendant's Lexus missing pieces of her right rear taillight at about 8:03 a.m. that morning?
Would that be? I'm not sure which video that is.
Well, it's not a video. If we could put up Exhibit 10. It actually was from a video. Did you look at this picture during your differential diagnosis?
I think I've seen that picture before.
And
The
could we
car,
have
the vehicle parked. Yes.
Exhibit 11, please. Did you consider this picture in your differential diagnosis?
I didn't. I don't know that I ever saw this picture.
Seeing this picture, do you see that the right rear taillight is missing pieces?
I can't even see that. Oh, yes, I do see that. But again, these pieces would have to be lined up in a certain configuration in order to cause those wounds.
So seeing this photograph now for the first time, it doesn't in any way shape or change your opinion, does it?
No.
You had, as a police officer, when you're excluding the source, and in this case, you're saying the cause of Mr. O'Keefe's scratches on his arm could not have been from a collision. Do you listen to witness testimony or do you review witness statements?
Objection, Your Honor.
I'm going to allow that. Just, do you do that?
As a police officer, in investigating a car accident, is that what you're asking me?
Yes.
Did I listen? Did I take witness statements?
Yes.
Yes.
And do you value the statements as part of your analysis?
I give varying values depending on what I believe to be the veracity of the witness.
Have you listened to the statements of the defendant herself in this case regarding potential impact?
No. What do you mean?
Well, have you seen any statements made by the defendant to any media about potential impact or collision in this case?
Oh, are you referring to what you've asked me previously about, did I hit him or something of that? I don't, what do you mean specifically?
Have you seen any of the media statements by the defendant, 2020 Nightline docuseries? Have you seen any of these statements in your analysis of whether or not there was a impact, a collision between the defendant and her Lexus and Mr. O'Keefe? Have you seen any of those?
I did see some statements, but that was after I rendered my opinion.
And some of those statements, after you rendered your opinion, did some of those statements come from the defendant herself?
Yes.
And when you listen to those statements, did you hear any of them talk about the idea or issue of collision or impact?
Yes.
And when you listen to those statements after you formed your opinions, did in any way change the analysis of your opinion?
Absolutely not. And I'll tell you why.
Please do.
Because she had, the defendant had undergone a very stressful event, finding her loved one in the snow. And so after a stressful event, many people suffer from what's called an acute grief reaction. It's very common. And they do things that seem to be irrational. They ramble. They act bizarrely. They make statements that are irrational, that don't make sense, and they oftentimes tend to blame themselves for whatever has happened. I've seen this many, many, many times in the emergency department.
Does this happen moments after a stressful event?
Oh, yes.
Does it happen months later when you go on 2020 or Nightline?
I've never seen that situation.
No. Does it happen a year later when you go and speak to documentarians and be interviewed? Is that the same kind of condition you see a year and a half later?
A grief reaction can last years. It usually is very brief, but it can last years.
Now, when you looked at the clothes in this case, Mr. O'Keefe's clothes, you are aware that those clothes were swabbed for DNA traces, aren't you?
Yes, I'm aware that some of the clothes were swabbed for DNA.
Could we have exhibit 147B, please? On the right arm, there were a number of different tears in that fabric that you looked at, weren't there?
Yes, there were a number of small round holes in that
You're
fabric.
aware, aren't you, that those holes were swabbed for traces of dog DNA?
Objection, Your Honor. Like to approach, please.
Okay, come on up.
Sidebar number 2. Hello, Maye. We ended yesterday with the objections being 11 for the defense and 30 for the prosecution. However, after you left, I had stated that because Dr. Russell was still on the stand when we left, we would continue counting until she's off the stand today. So the current total is 22 defense and 30 prosecution. So you still got a good chance on winning this bet. The head wound, Teresa. The bleeding in his brain caused by the head wound is in the contributed by hypothermia was the cause of death. Good morning, Z baby. Yup. Yes, Mr. Waffle, you are closing in. I thought it only fair since they did not finish her testimony. But we'll end it when Dr. Russell leaves the stand. Oh, his weight? Oh, I don't remember. I'm sure it's in the room though. Do I have the autopsy in the room? I'm not sure. Let me see if I can track it down. Hmm. The cause of death from testimony, Teresa, was exactly impact injuries to the head in hypothermia. Hmm. I think I have it. Oh, nope. They took it down. Okay. I had it. It's 4:04 now. Okay. Here you go. I got your link, Liam. Hopefully you can find what you're looking for in here. Um, I'll also put that link in the room. The, you know, I will say that Hank Brennan is really taking a long time on this cross examination. He's getting up there in Alessi territory, actually, for the length. Because we had we had a little while yesterday, and now we're at like, closing in on 2 hours plus. Mhm. Oh, Jin, was it 216 pounds? You remember that, Jin? Or did you just find it? Good memory if that came right off the top of your head, Jin. I didn't remember. I had to go look for a file. Hmm. Uh, Trying to think if it's on the certificate or not. No, and they don't they you know what, I just saw that on that link they don't actually have the actual file, the report. I have to keep looking.
taking longer than any of us wanted to do while you're sitting here. So we're going to continue what we're doing, but we will give you the morning recess. So let's say about a half an hour or something. Okay?
All rise for the court, please.
Okay,
Those
so it
gentlemen,
looks like
follow me.
she's not off the stand, but we are going to take a break. They're going to take a break, actually, the jury, as they are going to continue. I wonder if they're going to do this in front of us without the jury, or if they're just going to continue deliberations and we're just going to sit here and talk amongst ourselves. Oh, we get to
Sam, watch your
listen.
step coming down. Follow me.
Jurors exiting the courtroom, please be seated.
Ouch.
All right, Mr. Alessi, I'll hear you. Mr. Alessi, I'll hear you.
Thank you, Your Honor.
Excuse me, Mr. Brennan.
Mr. Brennan, can you remove? Oh, okay, it's being removed.
Thank you, Your Honor. Attorney Brennan, just with regard to Dr. Russell, in open court in front of the jury, used the concept of DNA in this case. He has introduced it and brought it in for the very first time in front of the jury. He has done so intentionally. He intentionally brought up DNA. Based upon that intentional mention, the defense moves strongly, vigorously for a mistrial with prejudice. A mistrial with prejudice. There has been no mention in this trial of DNA with regard to the topic, with regard to what Mr. Brennan has raised. There has been none. Specifically, the prosecution had, in the first trial, had a witness, Terry Kuhn, with regard to DNA. For whatever reason, the prosecution has chosen not to bring that witness in who would testify perhaps to DNA. As a result of that strategic decision that the prosecution made, there's been no mention. I want to be very clear. The defense has been incredibly assiduous and meticulous about not mentioning DNA in any fashion, directly or indirectly. With regard to the hoodie shirt and the hole, the only thing that was adduced in direct examination was a mechanical function, simply of Dr. Russell testifying that a dog tooth went in and came out and caused a certain mechanical effect on the yarn. Nothing even close to the mention of DNA. With regard to representations that Attorney Brennan has made, that somehow there was a hearing that we were on notice, it is completely incorrect. Show me the hearing, show me the transcript where that has been discussed. The prosecution has also said, we're going to, or we always intended to bring on rebuttal, Dr. Crosby, who would talk about the supposed absence of DNA, the alleged absence of it. The problem with that of trying to rescue the mistrial that the prosecution has caused with prejudice is that Dr. Crosby could never testify about such a topic, because I would object because there would be no foundation, because the prosecution strategically chose not to bring in the foundation whatsoever in this trial. The fact that they did it in another trial or perhaps did it is irrelevant to this trial, as Your Honor has admonished several times. What happened is, this is a new trial, and whatever happens in the first trial is the first trial. So in conclusion, Your Honor, because of the conduct of the prosecution, and specifically the intentional mention of DNA, the prosecution has put in the jury's mind that topic that is irremediable. That cannot be reversed. That cannot be cured. That cannot be ameliorated with a jury instruction. That cannot be dislodged. The prosecution has to suffer the consequences of its own intentional actions of bringing up that topic. Ms. Reed is entitled under the Constitution, under the Massachusetts Declaration of Rights, to a fair trial. And what has just happened is antithetical, abhorrent to a fair trial. The only remedy is a mistrial with prejudice.
Okay, thank you. Mr. Brennan.
Inquiring of Dr. Russell about the absence of dog DNA is not only proper and permissible, it's essential, and the Commonwealth is entitled on cross-examination to explore theories and facades that the defense creates if there is actual evidence that undermines or contradicts the representations that they are trying to portray to this jury. Let's be clear. The defense is on notice that there is no dog DNA in the sweater of John O'Keefe. Let's be clear. The defense is on notice that we were not going to try to disprove all of their varying theories in our case in chief, but if they were going to propose theories that we thought were unsubstantiated, we would do so in rebuttal. It is clear these witnesses are on the witness list. More so, the conversation and examination of Dr. Russell is replete in the historical record of this case. Dr. Russell herself testified on December 12, 2024, that she did consider the absence of DNA in her opinion. She disregarded it. She discounted it. She created false theories about the potential destruction of it, but she did testify this was part of her consideration for her opinions. Again, on January 7th, 2025, Dr. Russell again discussed the absence of dog DNA in John O'Keefe's sweater. Now, it may be inconvenient. It might be hurtful for the defendant's theories, for the creation they portrayed for this jury yesterday, but it is not improper. It's not unconstitutional. It's not irrelevant. It's very relevant. It is powerful evidence that the Commonwealth has to undermine this idea that the linear superficial abrasions on John O'Keefe's arm were somehow caused by a dog. They, on their case in chief, tried to create impressions about the cause of the abrasions to Mr. O'Keefe. The defense does not get to pick and choose what words the Commonwealth can or cannot use. They do not get to pick and choose what parts of Dr. Russell's opinions are important and not important. Because they chose not to emphasize, highlight, or discuss the absence of dog DNA on direct does not mean it's beyond the scope of direct examination. It means they did not want to talk about it because it was not helpful to them. There have been countless cross-examinations in this case where questions are asked beyond the scope of direct. This is not beyond it. It goes to the heart of her opinion. If I cannot cross-examine her, as proposed by the defense, about the heart of her opinion, she shouldn't give it. She shouldn't have an opinion, because you can't come in and just take the favorable factions to yourself and leave out reality. I intend on asking Dr. Russell about her opinions, about the role that the absence of DNA played. Also, I expect to ask her about her attempt to diminish or demean the DNA evidence, because it shows her inherent bias in all of her opinions. where she acts as an advocate, not as a scientist or a doctor. It is admissible evidence. We intend on using it. And when she returns to the stand, these are the very questions I'm going to ask her.
Your Honor, may I have a brief 1 minute?
Sure, go right ahead.
Thank you,
Mr.
Your Honor.
Alessi.
Your Honor, a key misstatement of fact that Attorney Brennan just made. He said that Dr. Russell talked in prior proceedings and hearings about dog DNA. The record is abundantly clear. She only did so in response to a question from Mr. Brennan. I have the transcripts right with me. She never raised it affirmatively. She gave her opinion that these wounds were to a reasonable degree of medical certainty from a dog. Mr. Brennan on cross said, did you consider, and this is in a prior proceeding, did you consider DNA? She gave her answer. She didn't raise it. I heard it. I was there. Your Honor was there. So this impression that Mr. Brennan is trying to give, that somehow the defense brought this topic up before, is incorrect. The second point, Mr. Brennan needs to have a good faith basis to ask the question. To have a good faith basis, he has to have some admissible evidence that he's got for it. He has no admissible evidence on dog DNA with regard to the arm. He knows he doesn't. He strategically chose not to bring that evidence in this case. Now he's saying he wants to use it. That would be improper in this trial for that reason. The other 2 points quickly. Mr. Brennan alleges an absence of dog DNA with regard to these wounds in the right arm. There was no swabbing of the wounds of the right arm of Mr. O'Keefe. That is a major, major investigative flaw in this case. That should not be befallen upon the defendant. Secondly, there are, with regard to the hoodie, that was one, I believe, swab taken, and we don't know much about it, but what we do know about it is there are horrible, tremendous chain of custody and care with regard to the hoodie, conceded, virtually left on the floor of the ambulance, left on the floor of the hospital, carried around by Mr. Proctor for weeks, maybe even months, not submitted for testing for months. There are huge issues that prevent a fair determination about whether there was even proper determination of whether there was DNA or not. So in conclusion, Your Honor, the defense has never brought up DNA or alleged absence with regard to the right arm of the hoodie. It's always been the prosecution. We were meticulous and assiduous in not doing it here. The prosecution needs to live with the consequence of its action. This is remediable, and I respectfully submit warrants only one ruling respectfully, and that is this trial must be declared a mistrial with prejudice.
I have 30 seconds.
Sure.
The defense can pound their fists and yell as loudly as they want, but they can't change truth and reality. Whatever the motivation is for wanting a mistrial can't be based on a claim that the prosecution raised DNA for the first time with Dr. Russell at the Lanigan hearing. If we actually look at facts and reality, rather than making false claims about everybody in the courtroom and everybody else who comes in here, what we'll see in the transcript, and this is the December 12th, 2024 transcript, I direct the court to the direct examination of the attorney who just accused the government of raising it for the first time. Despite his words,
what page
we have page 83, line 21. We have page 122, line 14. We have page 124, line 14. These are the words of Attorney Alessi on direct examination. And there are more. There are more. But that is enough for the court to understand that the representations are wholly mistaken by Attorney Alessi. Wholly.
All right, thank you. We'll give everybody a half an hour.
All right.
Wow. So, depending on what she comes back with after the half hour, this may be over. Or we may be done for the day, or I don't know. But you know what? I will give them this. It's about time. It's about time the defense was paying attention and got off their ass and actually lawyered this case. Yeah. Instead of like dealing with conspiracy and circumstances in just innuendo. I'll give Alessi credit. Besides the pounding and the over dramatics, I could do without that. That was some damn good lawyering, catching that and trying to use that to get a mistrial. And why not? Things are getting hot for them. Things are not going their way. Nobody believes this conspiracy crap because the timeline does not fit. Even if the jury does believe they could possibly be dog bites, there is no evidence of it. It's only opinion of Dr. Russell. As expert as she is in medical training and all of that, she ties no physical evidence into it at all in the how, what, where, and when to conclude that it was not the fact of the timeline that Karen and John were in the same place within minutes, that a vehicle went into reverse and he stopped moving forever within a minute. Okay, no matter how much they tear it apart, that timeline doesn't disappear. So it's actually totality of evidence. And I hate to say it, like people can throw anything they want at whatever happened in the investigation and all of the messiness of the trial. Because I'll admit, this case is rampant with everybody making mistakes, and we'll take ever. But I will say that was some good lawyering. But perhaps, Alessi, if he wants to call for a mistrial, maybe he forgets about Alan Jackson lying to the court to their face. And we didn't get a mistrial and get everything thrown out then. He didn't get thrown out. The court will decide what is fair. The judge will decide what's fair for both sides. Okay. And there is actually, besides all the pounding that Alessi did, there is remedial on it. They still get to redirect. They still get to point out at this point how bad the investigation was, that nobody bothered to test for any DNA anywhere. That could be made public to the jury right now, and that is a remedial to this actual thing. But the fact that there's no dog DNA is a fact of the case, whether it was tested for or not. And he can ask the expert. She has no physical evidence of anything. She's looking at a photograph and using her opinion. And she feels she has the qualifications to do that. But what she can't do is stand behind any physical evidence of anything. And that's what Brennan was pointing out. What evidence did you look at in this case? Was there anything of this? Was there anything of that? Was there anything of that? And the answer was no, no, no. And I'm sorry that looks bad for the defense. I'm not really happy with a lot of what Hank Brennan did in this cross-examination, actually. I think he was way too snarky and made some aggressive remarks that didn't need to be done. I don't think he needed to embarrass this witness in regards to her memory. I don't think he needed to make those comments. I think her memory was at issue. And I think that would have came up with him just keeping to actually present the transcripts and keep asking her the questions. He did not have to make the snarky remarks. He gets bad manners for today. And I like, this prosecutor. I think he's a damn good lawyer. But it was nice to see, besides the theatrics, I could do without the pounding. I mean, I don't know if Mr. Alessi thinks he's in a Perry Mason moment or what, or maybe it's the cameras, but that was a bit much. I do admire his passion, though. But that was damn good lawyering to catch that and make the oral argument for mistrial, because that's what a defense attorney should do. That's how you should defend your client. Not making up stories, not giving improbables. Damn good lawyering. You know what? I agree with you. It's like a Perry Mason moment, right? He does play righteous indignation to a T. He's got it. He got it down. It was entertaining, but it was for who? Because the jury's not in there, and I don't think Judge Cannone appreciates it. She's the one that has to make the decision. So, but it was good lawyering to bring it up. I have to give them that. And it was nice to see actually for a change. I'm impressed. I'm always going to call it like I see it. And that was. And I don't know which way she's going to go with that. But the fact is, DNA has come up repeatedly in this case. This is not the first time this came up. I distinctly remember it in Lambert, and I do believe it came up in before. I do. Yeah, I thought it would get a response, but that was way over the top than what I was prepared for. Yeah, but you have to admit, damn good lawyering. Somebody's paying attention, and he was ready. And you know what? That's what they're there for. But they're not messing with the lightweight either. Hank Brennan was prepared too. Hank Brennan is prepared for his crosses. He has all the transcripts there. He has everything. He kind of thinks ahead on where things are going to go, and he was ready. He was ready with countering that. It was a Perry Mason moment. It was good. It was definitely good. But now what do we do? Like, wow. And what happens if it's actually another mistrial with or without prejudice? Well, if it goes with prejudice, they ain't going to file again. Well, if it goes without, will the Commonwealth actually file again? Will they actually go forward with another trial? Or will the people of Massachusetts stand behind that? This is true. It's an extremely expensive team for them to not be ready to jump on every procedural impact. Exactly, but they haven't been, Liam. If you've been watching the lawyering, and I know you have, along with I, from the beginning, their lawyering is sloppy. They often take that podium without the documents necessary. I mean, they've even tried to impeach people without the proper documents and have gone out of discovery. They have, really tried to get away with a lot. With a lot. Anyway, that was not something I expected. I didn't have that. That's not on our bingo card. Rocky Couch. I think we need to add Perry Mason moment as a bingo square because this trial proved there's going to be a lot of them. I think it fits so many things that have happened. It would have fit in the Murdaugh trial every time Harpootlian got up there and tried to make his little thing, or when Jim Griffin got up there and was shaking and wagging his finger. Or Rottenbottom in the Depp Heard case, when he got all indignant. Yes, my God, King. We got true tables, ladders, and chairs match here. Yes, we do, Jen. Yes, we do. Teresa says, why can't they mention DNA? Wouldn't that be important information to know? Here's the problem. The mentioning of the dog DNA, no testing was ever done. He's trying to throw a curveball a little bit in there. It was mentioned throughout, okay? And she said that, she didn't look for it. The testing wasn't done. They don't want, she can sit there and say that those are actually dog bites by her opinion. She's allowed to have her opinion. But Hank Brennan's trying to prove there's actually no physical evidence that concurs with it. That there's just as much possibility that it's not. I mean, as far as physical evidence, I guess you could consider the holes in the clothing as physical evidence, but in the holes in those clothing, there are actually pieces of red tail light. Would you mind adding that for me, Rocket Couch? I think it's a good square to have. There was a lot of filing today. Because of the faulty investigation, they are again asking to bring in the defense. They, being the defense, has filed again for Beverly Cannone to actually, Judge Cannone to actually reconsider her motion to exclude Michael Easton's testimony and not go after the investigation as a whole. This would be the second time they have requested her to review it. It was denied the first time out. They requested again before trial, and they're going to request now. And as far as the absent witness, I did put the filing in the room, in the library, in the read room. They clearly are saying it's Proctor, Higgins, and Albert, and that the prosecution is not bringing them forward because it would benefit the defense. However, they are on the defense's list, and they can clearly bring them forward if they should. After all, the Commonwealth's case in chief is not about the conspiracy. It's about the vehicle hitting him. That's the case they're presenting. Why would they present the other witnesses in regards to whether or not he was in the house when there's no evidence pointing that way? Nor did the investigation go that way. The dog bite thing didn't come up until before the first trial, well after the investigation, well done into the investigation. And honestly, with the DNA sample still being at the lab, I mean, couldn't the defense actually pay to have that testing done also? That's what I think. I mean, couldn't they? I think it was only once, okay? And I think that, I understand that the abrasions, but the way that it was explained, and this isn't me saying, standing up for it either way, I'm just saying the way it was explained, Stephen, is that if his arm was in motion, coming across the jagged ends of that broken tail light, it's got multiple wounds, it would have happened. The stomach and the pancreas are both damaged, but not enough. But they said that's the hypothermia in the blood, the lack of oxygen, not from impact, Stephen, on the autopsy report. So you keep bringing up the stomach and the pancreas, and if they're saying no. There are multiple wounds on the arm. They're trying to show that it was a rotation. That's what I can't figure out either. I mean, it's a possible, but like you say, is it plausible? There's reasonable doubt there. For me, it's not about the accident reconstruction at all. I don't care about any of those videos. I really don't. It's the timeline for me with the digital evidence. You know what I mean? If we go back to the medical examiner's testimony, I think that was brought up, Stephen. I forget what day it was, but I do mark the videos in the timeline, at least, would be there. I could go back and look, but I'd have to go through my notebooks. Only have the current one with me right now in front. Well, I could get you that information and put it on in this video, on the comment section of this video, what day it was for you, because I'd be able to tag you that way. Or during the lunch break, I will be able to find it for you. You know what? I'm gonna find the day for you at least. Oh, day 25. That's only a couple of days. Wait, this is day 26. There's no way the medical examiner testified yesterday. Oh, they're counting. they're counting the jury selection and I don't. So, okay, let's see. All right, so that would have been just a couple of days ago. Let me see if I can see. Oh no, that's Dr. Marie Russell they're talking about. I want the that wasn't okay. That Google's being all right. May 15th, Thursday, May 15th, Dr. Irina Skorda. Okay, so that would have been let me just go back and look on my thing. May 15th. I might be able to find you the testimony, the video. Hold on. It does list the days. Okay, so the 15th was day 16th day of trial. So let's see if it was the morning or if it was the afternoon. It was this video. Okay, hold on. I found the video of the Emmy's testimony if you want it. Oops, stopped it. Here you go, Stephen. This is the Dr. Irina Scarabello, or however you say it. This is her testimony in here. It's time-stamped in the description, so you can go right to it. It was day 15 of this trial. Oh, yeah. Hey, it's not an effort. I like to answer the questions. So thanks for asking a question and giving me something to do, actually. I want everybody to have the information. I don't want to try to convince anybody of anything. I just want to point you all to the same things I hear and stuff. Like, we all have our opinions on it, you know? Hey, man. How you doing? How's your day going, love? This is kind of embarrassing, Mandy. But it is going to give us a new bingo square. We're going to put Perry Mason moment on the bingo cards for live trials and hearings. Yes. It must be the moon, Mandy, because like even in the Daybell trial, like even in that for jury selection, what the drama was unbelievable. And did you see that Taylor Shabanos, like they wheeled her in all tied up in a wheelchair? Like, talk about some like wow drama this week in the trials. Also in the P. Diddy case, the witness that didn't want her name out there was actually all over the socials with her name in a video. She did some happy birthday video on Instagram for P. Diddy, and everybody linked her to it. And it's everywhere now. So there's that. It's that kind of week. Oh, I know you can't have them in the middle of the day. I don't expect you to, Rocky Couch. It's just for the future. I understand. We don't want to rearrange everybody's cards. That's for true. You know? You know what, Stephen? I hear you. I like the rules too. And I love this just justice system, as flawed as it is. That is my fascination, and it's been my passion. And I will admit, this whole case is messed up. There was a lot of things that went wrong, and a lot of things that just shouldn't have been. But for me, it just comes down to a certain amount of evidence. But I have said, just because that evidence convinces me, there's definitely some reasonable doubt here that is able to be raised by the defense, and the jury could look at it that way, that they just haven't proved their case because of the faulty investigation, because of some things that have happened. So, I had said that from the start. As much as I actually think she did it, I do. I will, I do. I think her own words and testimony, her own actions since then, and that timeline, they convinced me, but I'm not on the jury. I also think the defense could have been a little bit more above board in doing their reasonable doubt. And I think they caused their own problems in being actually losing credibility right in front of the jury repeatedly over some of their own tactics. They, but the jury didn't see a lot of it either. They didn't see the candor of the court issue in regards to the arc of witnesses with Alan Jackson and the deleting of messages. They didn't see any of that. And they're not, and supposedly this jury hasn't seen anything from the first trial for witness intimidation. However, they have seen plenty of it in this trial, with the way certain witnesses were attacked in the beginning with Alan Jackson's bulldog style that he's famous for. Did the same thing in, the Weinstein and the Spacey trials when against witnesses. It's what he's known for. That's his style. That's what he does, So, but it didn't go over well. And I noticed he changed it somewhat. He toned it down a little bit. Oh, why is that thing stopping? Oh, you better not drop my feed there. Okay. I don't know what that was about, but their feed hesitated, gave me a little bit of a heart attack. That's how we do it here. Not everybody agrees, Stephen, so I'm glad that you're open for it. And ask the questions, and we'll try to get you the information the best we can. Just because I have an opinion about something doesn't mean that everybody can't have an opposing. And often, some of the people that have been with me since my first trial, way, way, way back, we often disagree. As a matter of fact, my friend Mandy, who's in the chat, we have disagreed about cases, and we've still been friends the whole time. And we will actually stream together on it and give opposing views about things. It's about open, honest discord. It's about having respect for the system, and just trying to put everything out there factually the best that we can, But I would admit it doesn't mean I don't have an opinion or that I don't say things, about how I feel about stuff, because obviously I do, Thank you, Couch. You know what, Couch? I agree with you. It just starts too early in the morning, and by the time it's done, I'm exhausted. I get it. And I'm actually going to do a true crime tonight. I'm going to try to stay on schedule for 7:00 tonight. But this one does suck the life out of me. I tell you, like, I like the later ones. I do. The investigation definitely shows the more local and state law enforcement are in need of better training and being equipped with more appropriate kits. And this did come up. In fairness to the Massachusetts State Police and the local police departments, there was a major investigation and an inquiry to all the departments in the handling of everything. And they did point it out that there wasn't any intentional, hiding of evidence, altering of evidence, or anything like that. But there were things that they could do better. And a report was issued on things, like the collection of evidence, like taking the time to do certain things, in having kits available more often, and that's being addressed. So I see them willing to improve it. And in their defense, they all cooperated with that investigation. And that's separate from the FBI investigation, which, by the way, was instigated by David Yannetti and Karen Reed, themselves about things that her feeling that there was a conspiracy and that there were things going wrong. And, rightly so if they do. But that investigation concluded with no one else being charged and no wrongdoing being found. And, well, that shouldn't come up in the trial because that was separate. And that would be quite prejudicial. Even though they wanted to bring it up when the investigation was going on because it made everybody look bad. But now that it's concluded, it's not coming in, Except for it did come in yesterday with Devers because she brought it up because she talked to the FBI during that investigation about her testimony. Hey, Roddy. I did see the Lori Daybell wheelchair incident, but the actual video is so bad coming out of the court, it's just audio, that I posted the Idaho News, East Idaho News link to it because it's just not worth re-recording for me. It's like that bad, but boy, oh boy, was she given quite the show, did she not, Rodin? We're going to be talking about that tonight, actually. That's one of the small things that I'm adding to the list for tonight. Yeah, I know, Liam. Like, definitely they could have watched some Law and Order episodes and did a little bit better, but that's all water under the bridge. At least they did do an investigation of it and an inquiry and came up with some areas of improvement. Yeah, Rhoda, that was actually quite funny. But you know who else showed up in a wheelchair all strapped in? A security wheelchair was Taylor Shevenoff, so she doesn't attack anybody in her hearing today. Yeah. Exactly. He doesn't like me. Mom, he doesn't like me. Throw him off the case. I know. He actually had to inform her, no matter what you do, I'm going to be your trial juror. I was ordered to stay on the case. That's the way it is. So no matter when we do this, it's going to be me. It's going to be him. He's really lost all patience. I wonder if they're testing her for diseases right now because I don't think he believes her. I heard in that audio so much sighing going on. It was the same with Murdaugh. There was a lot of things that could have been different. And the Murdaugh, just having everybody who knows everybody all over the crime scene was atrocious. How it ended, and the rain starting, and they're doing their best to try to preserve the evidence. But at least they did make some good effort there with the footsteps and everything, what they did to preserve the indentions and everything. At least many of the officers there tried, but there was too many people at that crime scene, too many people up in the house, yeah, there was a definite problem with all of that, Liam, too. Everybody knew everybody. There were more lawyers on that crime scene than anything because, that's how connected, Alex Murdaugh was. I can't believe it's only 20 to 12. They're gonna come back and then they're gonna go to lunch. I know it. I just want to hear this decision. It's been more than 30 minutes now. Is she looking for a mistrial because of? I've heard there's a lot of She didn't look at the debrief. She didn't look at anything. Stop yelling, Mandy. Calm down. It's okay. We all heard her. She didn't look at anything. As a matter of fact, she's a perfect example of confirmation bias. As great she is in her training in medical, and I don't want to disparage her knowledge at all. But as far as an expert witness for testifying in court, she's really, really bad because everything she testified to just proved she had confirmation bias. She had made her opinion up after looking at she didn't care about anything else. For her to be able to say that he wasn't hit by a car, but he didn't look at this and he didn't look at that, and she doesn't even know about the taillight pieces and this, Like, you know what I mean? Not good. Absolutely not good. Total confirmation bias here. Like, she's just looking for ways to prove what she thinks is going to happen. After all, she approached the defense with the clear idea that she could help them about the dog bite. There was no doubt what she was going to testify to. She wasn't really looking at evidence to prove it. She was convinced this was what it was already. At least that's how it looks to me. And pretty much got confirmed in the cross-examination of Hank Brennan. You know. It's just, I just understand how she feels, Liam, because it's so frustrating, you know. But Hank Brennan did do a good job of pointing out the fact that she has never testified in court before as a dog bite expert, bringing out the fact that, like, who does she think a dog bite expert is, you know. But I hear you, Mandy. I think we all need cuddles after Alessi. Did you get to the Alessi yelling part yet? Because otherwise, like, hold on. That Perry Mason moment is epic.
You are unmuted.
And we're back. About time.
Please be seated for the session.
Oh, no jury yet. Let's see what she says.
All right, so the motion for mistrial is denied. Your rights are saved. And Mr. Brennan, you can continue with this line of questioning.
Woo!
All right,
Oh,
did
they're
not address
pissed.
sidebar the other issue that's under court's consideration regarding Dr. Walsh's opinion.
Yeah. I don't see it without a foundation. So if you can build a foundation, I'll consider it. I do not believe that foundation has been laid yet.
I would expect that foundation would need to be substantial, specifically whether or not it was relied upon by the witness.
Yes.
Could you do that outside the presence of the jury so that I don't ask the questions in front of the jury?
Oh, yes, but not right now. They're on their way. All right. Do you have enough?
I'll work around it.
Okay.
I'll work around it.
Your Honor, I would object to being done outside the jury, that it should be done like I've had to do with several witnesses in front of the jury.
Okay, if that's what the defense wants. Are you sure, Mr. Alessi?
Oh, wait, I'm sorry, let me confer with my.
That's pretty dangerous to allow him to do it.
We are going to.
Oh dear.
Thank you, Your Honor.
Okay.
You're on the way, Your Honor.
Thank you.
I'll be done very quickly, so I'll have to make that decision.
Is the lunch? Are the lunches here?
Jury's coming in.
Are they still over there?
Liam, when you say that, I know you're saying that tongue in cheek, but like, don't do that, because the next thing you know, I'm going to get attacked. But I know
if
you're
they're
saying that.
downstairs on their way up, I don't want to stop them.
I can do it in 2 questions.
Yeah, please.
Oh. Excuse me?
They're still this way.
Great. Okay, they're going to stay.
Your Honor, if it might help, obviously, with helping, so to whatever Your Honor does, based upon if Mr. Brennan only has 2 questions, I may have 30 minutes that I could, most 35 to finish up whatever redirect that I have, if that affects Your Honor's scheduling for the jury.
I just didn't want to stop them if they were on their way. They haven't yet gone downstairs.
No, I don't think they made it.
All right, we'll do this now.
So they're going to
Okay.
word there, Dr. Russell, in regards to DNA, so that they can give Dr. Walsh's opinion.
Dr. Russell,
Right there.
during your review of the case, did the defense offer you the report of John C. Walsh, MD, Deputy Medical Examiner?
I didn't hear the whole
I'm sorry.
question.
During your review, the defense provided you materials. Did they provide you the report of John C. Walsh, MD, Deputy Medical Examiner?
I don't recall.
May I approach?
May I-
Yes. Can we turn the fan off over here, Tony, please? Or thank you.
Dr. Russell, did you ever review or receive that document from the defense?
Mm-hmm.
Oh, yes.
And regarding Dr. Walsh's opinion, did you consider that when you formed your ultimate basis that the wounds on Mr. O'Keefe's arm were consistent with a dog bite?
Yes.
Did you disregard it or agree with it?
I disregard, I disagree with his assessment.
Thank you. All right, I'd like to inquire.
Your Honor, I would object. This is the same exact issue I had to deal with because the witnesses disregarded it, and I was not allowed to pursue questioning. So I do not believe, under the standards that's been set in this trial, that a proper foundation has been set.
What do you say about that, Mr. Brennan? How is this any different?
Pardon me?
I'm talking to Mr. Brennan. How is this different with this witness's analysis?
Because they specifically opened the door when they had her vouch for her own credibility, extolling her uniqueness and ability to determine that these were dog bite wounds. And so when they opened their own door to vouch for their own credibility and suggested that they're the only person or a limited person in the entire country that can do this, they should be confronted that they are not alone. There are other experts. And so this isn't affirmatively bringing it in. This is when the defense continually opens the door and creates these issues.
What do you say, Mr. Alessi?
Thank you, Your Honor. My response is this. I'll give two quick examples. Dr. Welter, Trooper Ball, Dr. Scordy-Bello. They talked and opened the door under Mr. Brennan's theory of opening the door widely. They even had, as part of their direct examination, documents in Dr. Welcher's slide that mentioned Dr. Scordy-Bello. You'll recall that slide. They even had material from the CARS team with a file named Trooper Ball.
I'm not letting it in.
Thank you.
All right, I'm not letting it in under that, Mr. Brennan. So you can mark the report if you want, but for that reason, I'm not, for the reasons stated by the Commonwealth, I'm not letting it in.
I don't need to mark.
Okay. All right, thank you, Hunter.
I'm impressed. That was good lawyering. That was good representation by Alessi for the defense. Because she did rule against them on that. And they shouldn't be able to use Dr. Walsh's report to show up this expert witness if they weren't allowed to do the same to the other witnesses.
An objection. Where are we? Is it in evidence now?
It's not yet. It will be.
Okay.
You guys just say 15 minutes.
The DNA. It's not, right?
It is not.
Okay.
Is there a question?
Yeah. Yes, it's open. I denied the motion and allowed the line of inquiry.
So he's allowed to bring up the DNA question, but he's not allowed to bring up the other experts' DNA report. I think that's so that we don't hear privileged information between the attorneys and their client, Stephen. They have microphones for the judge, for the witness stand, and for the podium. There's also a microphone somewhere near the jury because we hear a lot of stuff there. I think if we could see it, you see it right there for when they're like walking back and forth in front of the jury. If they're going to be talking about something like an opening and closing statements, I think I'm looking at one right there on that bar because that's where the jury actually sits, I believe. And actually this audio for this courtroom isn't anywhere near as bad as some others. Oh my goodness, we've had some really horrible ones. Yeah, Maggie, that was kind of rough about the report, but that actually came in and is on the record. So at least that came in. Yeah. I don't think this is gonna hurt Hank Brennan that bad. It's just something he wanted, and you just can't have it. You know. Yeah, sorry about that, Stephen. I would put closed captioning on, but it's often incorrect, and I'm just really bad about the misinformation. I won't use it. Sorry. You may be able to though on your playing of it.
Jurors, I appreciate your patience. All right, Mr. Brennan.
Thank you. Good afternoon, Dr. Russell.
Good afternoon.
Dr. Russell, we were talking about your differential diagnosis and your opinion that Mr. O'Keefe's abrasions on his arm were not consistent with impact or collision with the car. I was asking you specifically about some of the things you may or may not have reviewed before you formed your opinion. You looked on direct examination at a photograph in Dr. Welcher's presentation, and it had a photograph of a person who had been hit and died as a result of a collision. Do you remember that photograph you looked at?
The photograph of which one specifically?
There was a gentleman
I've
lying
seen.
on the ground. His face was redacted, and there was.
Oh, that one. Yes.
Remember that one?
Yes.
And when you discussed that, what was the reason? What was your point in discussing that?
I was answering questions.
Do you know what the point was? What you were trying to deduce or?
No, I was
suggest?
just answering questions.
Okay. You have stated before that one of the reasons you do not believe that the injuries were the result of a collision or impact with the car is because there were no lower body injury breaks. Do you remember that?
That's one of the reasons, yes.
You would agree that a side swipe or a clipping collision is different than a front or a back immediate impact, like being run over. There's a difference, right?
In general, yes.
When you talk about the absence of lower body breaks, do you have any studies about the frequency or the likelihood of lower body breaks in a clipping impact as opposed to being directly run over?
No.
When you looked at that photograph that was shown to you on direct examination, did you look at the actual injuries that were listed for that gentleman and see that there were no lower body breaks?
I looked at all the injuries, yes.
And did you recognize in that photograph and slide that there were no lower body breaks?
Yes, I did. There were major internal injuries, however.
When you considered the information in this case, did you have an opportunity beyond that photograph to look at Dr. Welcher's videos about impacting a vehicle driving backwards? Did you watch those videos?
I saw an image. I saw an image.
Did you see a video when Dr. Welcher put blue paint on his arm and showed the height and the location when it touched Alexis? Did you see that?
Objection, Your Honor.
I'm going to allow that.
Yes, I saw that image.
Did you consider what's called the text stream data? Do you know what text stream data is?
What?
Text stream, the black box that shows the operation of a car, how fast, how slow, acceleration. Did you look at any of that information before you formed your opinion?
I looked at it, but I honestly did not understand it.
Did you ask anybody to help you interpret that data before you drew an opinion that the injuries were not consistent with the collision?
Well, first of all, my opinion came long before that report ever came out. So the answer to that is no.
When you have an opinion, if there's new evidence that is contradictory or different or maybe undermines your theory, do you have an open mind to reconsider your theory?
Yes, I do.
Did you want to understand that information about the text stream data and the information that was available regarding this allegation? Did you want to understand that before you came back and offered the same opinion you had before that information was available?
I didn't understand it. And I didn't know that if any of the attorneys understood it, actually.
Did you know anything about Mr. O'Keefe's cell phone data when you were drawing these conclusions about when his last movements were? Did you learn anything about that?
No.
Did you know about any type of DNA testing on the defendant's rear taillight area?
Yes.
And did you know about any hair found on the car?
Yes.
Did you consider those things when you excluded the collision or impact as the cause of those wounds?
Well, I considered that. However, he had, my understanding is he had been in and out of that car, on many occasions. And so therefore there would be reason for either skin cells or DNA or possibly other, hair, fabric to be on that car.
So when you consider testing your conclusions, do you look at it as an advocate or do you look at it as a scientist or a doctor and try to value how little or how strong that evidence is?
I'm looking at it as a neutral party, a doctor, a scientist.
So you're not looking at it as an advocate to try to discourage the strength or weakness of evidence?
Excuse me?
You're not looking at it as an advocate? You're looking at it as an independent professional?
I'm not an advocate at all.
When you talked about John O'Keefe's sweatshirt, can we put that up, Ms. Gilman, please? You identified or discussed some of the tears to the right sleeve of Mr. O'Keefe's sweatshirt, didn't you?
We discussed one puncture to the right sleeve. Yes.
Having an interest in dogs and dog bites, certainly you're aware in your experience, when a dog bites, it creates quite a bit of saliva, doesn't it?
It can.
It can actually, a dog can froth, is what they call it, excessive saliva when it's in the moment.
Some dogs, yes.
And some dogs, they can shed hair, especially when they're interacting with other objects, don't they?
They could.
Hair is considered trace evidence, isn't it?
Yes.
And saliva contains important items sometimes like DNA, correct?
Yes.
And that's considered oftentimes very important trace evidence.
Yes.
And Dr. Russell, are you aware that one of the criminologists took swabs of holes on the left sleeve of the sweatshirt?
Objection, Your Honor.
No, are you aware of that?
Yes.
You've heard of UC Davis, haven't you?
Yes. And in reference to that previous question, however, the swabbing was done many weeks after the death, and there were images of clothing on the emergency room floor. So yes, I am aware that there was some swabs taken at some point.
Is that gratuitous answer part of your advocacy or part of your medical objective opinion?
Objection, Your Honor.
And so you're aware that these holes were swabbed to send a sample to UC Davis, aren't you?
Yes.
UC Davis, do you understand they specialize in dog DNA?
Animal DNA, I believe.
And you also know, and giving you before you gave your opinion, that when they were tested, there was no dog DNA found in any of the samples. You knew that, right?
Yes.
In fact, what was found was pig DNA.
That's correct.
And there's no identification where the pig DNA came from, is there?
I don't think so.
So when you saw the information, after you claimed there is a dog with John O'Keefe, when you saw the information that they were swabs done of those holes and the results were no dog DNA, did you consider that before giving your ultimate opinion?
Yes.
And in fact, you've tried to discount the significance of that evidence in the past, haven't you?
Yes.
In fact, you have made claims about that evidence candidly with no foundation whatsoever, haven't you?
I explained why why there could be no dog DNA found.
You were claiming that it was inconsequential because a number of speculative reasons, didn't you?
Objection, Your Honor.
So the objection sustained. You can ask it differently.
When you were discussing the absence of dog DNA on Mr. O'Keefe's sweatshirt in the past, were you trying to make suggestions that perhaps the samples could have been tarnished or compromised in some way?
That's one possibility, yes.
As a independent, objective expert, should you deal in possibilities, or is it a better practice, best practice, to deal with objective criteria in the form of actual opinions to a reasonable degree of certainty?
It would be best to go through a process to determine, or at least come up with a list of reasons as to why dog DNA was not found. There are a number of reasons. You know, if you have a test in medicine, you expect it to be positive, and it's not positive. You go through a process of trying to figure out why the case is that way. There are many reasons why there could have been no dog DNA found.
When you first gave your opinion, you didn't even know about that DNA testing, did you?
Not initially, correct.
But then once learning about it, you were not willing to reconsider and change your opinion about the source of these scratches. You maintained the same opinion you had before, correct?
I reconsidered, however, my opinion did not change.
What you suggested is there's possibilities, is the word you would use, possibilities why there were errors with the DNA. Yes?
Yes.
You can't tell us anything based in fact. Wait,
No.
I'm sorry.
Sorry.
You can't tell us anything based in fact to support the claim that something was wrong with the testing of this DNA, can you?
Not in fact, but again, you have to go through a process. If you expect a certain diagnosis or a certain finding on a lab test and it doesn't materialize, then you wonder why, and you want to know, was the test done correctly? You know, was the specimen handled correctly, et cetera, et cetera. There's a process.
And in that process, you found no evidence whatsoever, none, zero, to support any claim of compromise of that DNA process, did you?
Well, ideally, the swabbing should have happened immediately or very soon after the incident. So there was a delay in processing or swabbing to begin with. And then, of course, I don't know about the transportation or the chain of custody.
You were a medical examiner, weren't you?
Yes.
When you were a medical examiner, when you examined a person or their body, you did everything you thought was reasonably necessary based on the information you had, correct?
Yes.
Did you know at the time Dr. Scortabello did the autopsy, there was no claim whatsoever that a dog caused these wounds?
Yes.
Did you know that claim didn't come about until over a year later?
No.
And did you know that in response to that claim, that's why this was done at a later time? Did you know that?
Still, for a complete investigation, this should have been considered by investigators early on.
Even where there was absolutely no claim or evidence whatsoever that a dog caused these wounds?
Well, again, a complete investigation.
You can't tell us one step that went wrong with that DNA process, can you?
The process, no.
In fact, you have admittedly very little experience with DNA.
I have little personal experience with DNA.
And yet, although you're not an advocate, you are willing to advocate trying to undermine the strength of that evidence, aren't you?
No, I am a scientist, and I'm trying to understand why it could have been negative.
As a scientist and providing a medical opinion, do you try to exclude in your differential diagnosis all other reasonable causes of a wound?
Generally, yes.
And did you do that in this case?
Yes.
Now, when a dog bites a sweater, would you expect that it would leave DNA?
Yes,
When a dog bites a sweater, you would not expect it would leave little fragments of taillight shards in clothes, would you?
correct.
And so in this case, when you were developing your theory and differential diagnosis and excluding causes, did you consider that when Mr. O'Keefe's clothes were scraped, his pants and his shirts and his sweatshirt, what was discovered were minute, small fragments of broken taillight that came from the defendant's motor vehicle?
Objection, Your Honor.
I'm going to allow that.
Did you consider that?
I didn't know that at the time.
Could we have 201D, please? Dr. Russell, this is a photograph.
Okay.
Okay, I think is this sidebar number 4? Oh. Let me tally up the objections so far. It's getting a lot closer. We have 15, 26 to 30, depending on how the redirect goes. Getting a lot closer there, Mr. Waffle. I really did not anticipate Mr. Brennan going all morning with his cross exam. This is the longest I think he has. If we're counting the big long one where Alessi went on a rant about DNA, then yes, it is. Well, that one started with a sidebar and then they went public. So I did kind of count it. So I think that's how I got to 4. I'm not sure. Couch, I had 3 on sticks over there. That was quick.
Dr. Russell, were you aware that very small fragments, shards of plastic that match the broken taillight of the defendant's Lexus were found when criminologists scraped Mr. O'Keefe's shirt and sweatshirt?
Yes, I became aware of that.
Did you become aware of that before or after you came to your opinion and conclusion that Mr. O'Keefe's arm abrasions were not caused by a collision or an impact?
After.
And when you learned that, did you get a chance to see this photograph to see how small many of those pieces were?
Yes.
And would you agree that broken plastic, like broken glass, can tear fabric?
Yes.
Would you agree that broken plastic, like broken glass, can rub up against a person's skin, and if enough friction is caused, it can cause abrasions?
Yes.
Would you agree that if fragments like this were randomly in the sweatshirt, that it could cause cuts or abrasions to Mr. O'Keefe's arm?
I don't believe that fragments that are randomly in the sweatshirt or clothing would cause the parallel abrasions, the pattern of the parallel abrasions that we saw in the arm.
Do you know how Mr. O'Keefe fell to the ground and what movements his body and arm made as he fell to the ground?
Not definitely.
You don't know?
How? No.
Do you know how much distance or little distance he moved when he was on the ground?
Yes, approximately, I think it was 20 feet. I initially heard 60, but around 20 feet, I believe.
You think, do you know where his body was found on the side of the road?
Yes.
Do you know if his body, before it rested, moved or slid on the ground?
Yes, it did.
And it's your opinion that fragments like this could not have caused the superficial abrasions to John O'Keefe's arm?
You know, in reference to that last question, actually, that I don't know that there was a collision, but I know that it's alleged that there was movement of the body after the collision.
I wasn't asking about the collision, I was asking about his body. Are you telling us to a reasonable degree of medical certainty that these type of fragments that were found in his clothes could not have caused the superficial abrasions on John O'Keefe's right arm?
They can cause superficial abrasions, but not in that pattern that we saw on the arm.
I'm going to ask you the question again. Are you saying to a reasonable degree of medical certainty that these fragments did not cause the superficial abrasions to John O'Keefe's right arm?
Correct.
I have no further questions.
Okay. Mr. Alessi?
Thank you, Your Honor.
Okay.
Thank you, Your Honor.
Okay.
May I, Your Honor?
Yes.
Thank you. Your Honor, I would like to have published what is in evidence is 201A, and then I'm going to proceed after that with 201E.
Okay.
Dr. Russell, I have up this exhibit, and with regard to the questions of Attorney Brennan that he just asked about these alleged shards, can you tell the size of them from this depiction?
I don't even see any shards in that depiction.
Can you read that slide and see the handwriting that is there?
Yeah, it looks like clear app plastic collected from 7/18/18. There's another date over to the left side, and then it says AMV 6/29/23.
Right. And if Mr. Wolk, you could go back. Can you determine at all from this whether the shards are microscopic or not?
I cannot see any shards.
All right, let's go to 201E. With regard to this depiction, do you recognize what is in this depiction?
It looks like irregular, red colored pieces of debris.
Thank you. And do you recognize the ruler above those pieces?
I'm not sure if this is the same ruler as in the previous image, but there does appear to be a ruler.
If we could go back to the previous slide, does that at all assist you in determining whether or not it's the same ruler?
Not exactly, but there are similarities.
So let's go back to, flip back to the next slide. Does the, what is up in black help you reach any conclusion about whether those pieces are microscopic in size or not?
Well, so those are, again, I'd like to go back, but I think those might be 16th or 32nd of an inch if we're using the same edge of the ruler. Those pieces that are depicted are not microscopic because we can see them with our eyes, but they're extremely small.
All right, so they're extremely small. You've asked, you want to go look back at the ruler. Does that further assist you in your analysis as to the size of these pieces?
16. So those looks like they're maybe a 16th of an inch or less.
Okay, so let's go back, Mr. Wolf, one more time. So these pieces are a 16th of an inch or less, correct?
Yes, if we're using the same ruler.
Right. So with regard to, and if we could, Mr. Wolf, now go to Exhibit 1. Attorney Brennan asked you several questions with regard to whether those 16th of an inch or less pieces could cause these types of abrasions. You have addressed this issue, but I would like you to answer whether those pieces, a 16-inch or less, could cause, now knowing the size, whether they could cause these abrasions, including with regard to this pattern.
I don't believe so.
And with regard to that answer, how do you come to that conclusion? What is your thought process?
Okay, again, there are multiple parallel abrasions. So these pieces would need to be lined up in a certain configuration to cause those abrasions, and they'd have to be oriented in nearly the same direction because many of these groupings of wounds, and if I may use the pointer, are oriented in this direction a little bit. Well, anatomically, a little inferior to superior, ever so slightly this way. So they're oriented in the same way. So not only would they, those abrasions are rather large for those tiny pieces of plastic or glass, but they'd have to be oriented in a certain way to cause those wounds.
As an emergency department physician, as a forensic pathologist, what is the likelihood, if any, that those shards could cause those wounds?
You have to ask it differently, Mr. Alessi.
Dr. Russell, please state your evaluation and conclusion and the basis for it as to whether those shards of glass, or excuse me, shards of plastic, 1/16 of an inch and less, can cause those abrasions on and wounds on the right arm of Mr. O'Keefe.
I do not believe that they could have caused those wounds.
Is that a close call for you to come to that conclusion?
Not at all.
You were asked several questions by, please keep that depiction up, Mr. Wolf. You were asked numerous questions by Attorney Brennan where he wanted you to go section by section by section and evaluate each of, he grouped these, I think 5 or 6. Do you recall that questioning?
Yes.
Is that a scientifically proper way to evaluate this wound to determine whether or not it is from a dog? Is that a proper methodology to look at each individual section only?
No.
How, at a scale, is it improper to evaluate them that way under your methodology?
Sustained.
Dr. Russell, what is the proper way to evaluate the wounds on the right arm to determine whether or not they're caused from a dog?
To look at patterns, because individual wounds can vary, but the pattern is what is significant.
And on your direct examination, did you go through this method that you just described, a pattern and pattern recognition? Did you go through that in some detail and discuss that?
Yes.
Now, you were asked questions by Attorney Brennan, and in his questions, it was asserted that you don't have a standard, a published standard. Do you recall that questioning?
I'm going to allow it.
Do you recall the question asking whether you had a standard to reference for your methodology? You recall that questioning?
In reference to dog bite wounds, yes.
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 And with regard to the question and assertion in the question with regard to a methodology, you referenced studies and as part of your answer. Do you recall that discussion with Mr. Brennan?
Yes.
Do those, and you are those studies peer reviewed?
Yes.
And give the name, please, again, that we had gone over on direct, but give the name of the lead authors of each of those studies.
Yes. So one of them was by Dr. D. Munich, and the other one was Dr. Pollock. And by peer review, that means that it's the article was reviewed by other physicians in those respective specialties
So
of the authors.
I'm sorry to interrupt you, Dr. Russell.
I'm
You
sorry.
finished?
The specialties of the authors, yes.
We could take that down for a moment. Your Honor, may I approach, please?
Okay.
If I could have, Your Honor, for Madam Court Reporter, exhibits marked for identification PPP and QQQ.
Right.
And I'll start with PPP if I could, please. Thank you, Madam Court Reporter. May I present PPP to the, thank you, Your Honor. Dr. Russell, you have before you PPP. Is that the study with the lead author, Dr. DeMunich?
Yes.
Do you recall Attorney Brennan in his questioning asserting that you had no basis and there was no support for your methodology of pattern recognition? Do you recall that discussion?
Objection.
Sustained in that form.
Do you recall questioning on the cross-examination by Attorney Brennan as to your basis for a methodology in terms of pattern recognition with regard to dog wounds? Do you recall that?
Yes.
Can you please take a look at exhibit PPP for identification and identify whether there's any section in that study that talks about and documents the methodology that you used in that study?
Yes. So this is an article that was published in the International Journal of Legal Medicine, and it is entitled Forensic Approach of Fatal Dog Attacks, a Case Report and a Literature Review. And so it's several pages long, talks about a specific case, and then on page 298, there are some significant passages that I would like to read, actually. So it says here, dogs have some very specific dental and maxillofacial features. They have 42 teeth, 20 in the upper jaw, 22 in the lower. Usually the mandibular dental arch is narrower and shorter than the maxilla, and that means upper, lower and upper. Maxilla is the upper. Maxilla, and the shape of the dental arches varies among the different breeds. There are natural gaps between the teeth that are attenuated or accentuated depending on the breed. The canine masseter pterygoid complex is short and strong, and its insertion on the mandible provides powerful mechanical advantage. So that's talking about the muscles, how powerful they are. And then goes on to measure the forces.
If you could find the location, if there's any in there with regard to pattern, is there any discussion about attributes and patterns in that study?
Yes, this next paragraph. The above features attribute to the characteristics of dog bites. The maxillary teeth distal to the mandibular teeth allow the so-called scissor bite, in which the dog can lock onto his prey. The tremendous force of the bite muscle complex can develop, allows the dog to twist and tear, and cause great damage. The injuries caused involve a combination of biting, crushing, tearing that results in characteristic patterns of punctures, lacerations, avulsions of the skin and soft tissue. Forensic pathologists noted the multiple torn wounds with adjacent puncture wounds, the so-called hole and tear combination. That's in this case. The puncture wound, a round hole, is made by the canine tooth of either the upper or lower jaw on one side that serves as an anchorage, while the other teeth cut into the flesh, causing stretching lacerations in the process of biting, shaking, and tearing. This should be considered pathognomonic for dog bites, especially when accompanied by tissue defects and claw marks, the latter being narrow, superficial, linear abrasions arranged parallel to one another, 4 or 5 in number, and usually found in the vicinity of the bite. This pattern allows differential diagnosis with bites of other animals, which are not accompanied by pulling and shaking, nor by the usage of prominent canine, and with stab wounds caused by sharp instruments.
Does that study support or not support in the literature a pattern recognition methodology?
That's sustained.
What do you conclude from the language you just read in that study with regard to methodology of discerning dog bite wounds?
That pattern recognition is very important.
Now what I would like, if I could approach Your Honor.
Okay.
Sure. 298. If I could return this to Madam Court Reporter and please request Exhibit QQQ for identification. Thank you, Madam Court Reporter. May I hand it to the witness?
Yes.
Thank you, Your Honor. I've now handed you what is marked for identification as Exhibit QQQ. I would ask, please, that you, is that the Pollock study that you referenced in your direct and in your cross-examination?
Yes.
Could you please, as you did with the Munich study, can you please articulate the relevant sections with regard to your reliance upon that study?
Yes. So this is an article from the Institute of Forensic Medicine at the University of Vienna.
Is that a peer-reviewed study?
Yes.
Please continue.
Excuse me?
Please continue.
Okay. The title of the article is Fatal Dog Bite Injuries. And there's a summary. It says the dog's front teeth. So let me preface this. This was talking about a deceased child, and they describe the features. It says the dog's front teeth left marks of individual circular or scratch-like abrasions, as well as slit-like skin severances. Slit-like skin severances of the skin, arranged in curved lines. The pattern of the skin lesions largely corresponded to the anatomy of the dog's set of teeth. No tissue defects could be detected.
And is there any other section of that study that references pattern and pattern recognition methodology? Any other
Yes.
words, any other section? And if so, could you please read them?
Yes. So on page 491, there's a section called the morphology of dog bite injuries.
What does morphology mean?
It means the shape. And so it goes on to say the anatomy of a dog's teeth is the key to interpreting injury findings. The particularly long, cone-shaped, pointed canine teeth often create sharp-edged wound slits that can be mistaken for stab wounds. The bite mark on the skin is ideally a complete and congruent imprint of the front dental arch. Sometimes only the protruding canine teeth are imprinted. If the shorter incisors leave an impression, smaller skin lesions, parentheses, round pressure marks or streaky glide marks, can be found between the impact points of the canines. In practice, it is hardly expected that all 6 incisors will act uniformly.
I'm sorry, I didn't hear that sentence. Could you repeat that?
In practice, it is hardly expected that all 6 incisors of a jaw will act uniformly.
Is that sentence relevant at all to what you've referenced as an incomplete bite?
Yes,
How is it relevant?
because if not all the teeth impact, then you get a partial bite. You know, you get irregular appearances. There's another sentence that's important here. A gap in the injury pattern can have several causes. Oblique biting, so what that means is not dead center on, but off to the side a little bit. Oblique biting. Curvature of the body surface, which we could have in this case around the arm, the edges of the arm.
Mr. Will, could you please put Exhibit 1 back on the case? And Dr. Russell, would be helpful as you're discussing these items, if you could determine whether or not what's discussed in that study is at all depicted in this exhibit.
Okay, so we discussed oblique biting, which is off at an angle. Curvature of the body surface. So here we have a body surface that's actually quite irregular. There's curvature down here. There's definitely curvature around the elbow. And so there's curvature around the bones. So curvature of the body surface can change the appearance of the wounds. Interposition of textiles, so that would be clothing.
Is there an example of interposition of textiles in this case?
I don't think so.
Well, was the decedent in this case wearing any, is textiles mean clothing?
Yes, and I thought you
Was the
meant in this
decedent-
article, but yes, there was textiles in this case. Mr. O'Keefe was wearing that hoodie sweatshirt
Please
or
continue.
sweater shirt. So interposition of textiles, and then it goes on to mention some other things which I don't think apply in this case, such as different tooth lengths, tooth loss, abnormal teeth.
And is there any other aspects of that study that are relevant to your analysis and methodology with regard to evaluating the wounds in Exhibit 1?
You know, a lot of this article is relevant, and I don't know want to keep, you
I don't
want me
want
to
to, I
keep on
wanted to keep
reading.
reading it, but
Um,
if there is a section, because then I'm going to have a few more questions once you're done identifying the most relevant sections of the article.
Yeah, this. And then there's one section that says,
Thank you.
yes, thank you. Then it does mention that in some victims, parallel scratch marks originating from clawed paws are found accompanying the injuries.
And is there any other section that you believe supports your evaluation of the wounds on Exhibit 1?
No, I think that's it.
All right, so, thank you, Your Honor. May I approach?
Yes.
Thank you, Dr. Russell.
Mhm.
Thank you, Madam Court Reporter. So do those studies, the Demunic and the Pollock that you just referenced, do they support the methodology of pattern recognition that you applied in evaluating Exhibit 1?
Absolutely.
And do they directly or indirectly support that methodology?
Directly.
And is that medical literature peer-reviewed support or not for your pattern recognition methodology?
So as to the form, Mr. Alessi.
Do those studies, each of them, those peer-reviewed studies, support your pattern recognition methodology that you applied with regard to Exhibit 1?
Yes.
Did those studies look solely at individual wounds, or did those studies' methodology look at the overall pattern to evaluate and discuss wounds from dogs?
Ask it differently.
How did those studies evaluate wounds with respect to individual wounds and overall wounds? How did the study evaluate those?
They described some individual wounds. There were numerous wounds. Described some individuals, but they looked at the overall pattern to make recommendations.
Was the overall pattern in those studies important or unimportant in the analyses and conclusions that those authors reached?
Important.
Now let's switch topics. Attorney Brennan asked you about various considerations you made with regard to differential diagnosis. Do you recall those?
Yes.
Let's just start with your differential diagnosis methodology. You describe whether or not you took into consideration additional information that was presented to you in determining whether your initial hypotheses was correct or not. Describe just generally that process and whether or not you took new information and retested your hypotheses. Describe that process that you undertook just generally.
So in general, when a physician is presented with a set of circumstances or wounds or symptoms or whatever, they come up with a possible diagnosis, but have to consider other diagnoses as well. That's what a good physician does. They consider what they think is the most likely, and then they go through a process of eliminating the or including and the other possibilities. Would you like me to give an example, like chest pain or
Well, I'd
abdominal
like to
pain?
give you an example of what you used here in this
Yeah,
case as
okay.
the application of that.
Well, okay, so I'm just describing the overall process because if you came to a diagnosis and narrowed in on it and never considered any other information, sometimes your diagnosis is going to be wrong. And so you have to allow for other information. And so I did that in this case. You know, I examined the circumstances, examined the wounds photographically, and came up with my impression. But I also considered other possibilities. What else could cause those scratches or those abrasions?
And did you honestly and scientifically consider those other possibilities as you continue to review the information, old and new information in this matter?
Yes.
And did that process allow you to avoid confirmation bias?
Yeah. Yes.
So in terms of that process, now let's go through some of the items that Attorney Brennan discussed with you. He asked you several questions, one of which, did you evaluate news clips and audio clips? You remember that questioning?
I remember a question about some news clips.
And did you recall your discussion with Attorney Brennan about acute grief reaction? You remember that discussion?
Yes.
Now, in terms of acute grief reaction, you talked about it, and do you recall discussing that sometimes people who have a traumatic event, that acute grief reaction occurs? You recall that discussion with Attorney Brennan?
Yes.
Now, do you recall also mentioning that sometimes these patients engage in self-blame?
Yes.
And my question, among others, is when they go to self-blame, from your experience as emergency room physician, seeing patients with this, as you discussed with Mr. Brennan, are there instances when patients blame themselves for something when they're not to blame? Can you discuss what you meant by self-blame in acute grief reaction?
Sustained.
Your Honor, may we approach?
Okay.
Oh, my mic got stuck. Okay. This is definitely sidebar number 5. And the Commonwealth is now at 34 objections to the defense's 26. And it's 15 minutes to 1. Ay, ay, ay. He's not a psychologist, no. Well, he's trying to reverse some of what was laid out for the cross. You know, can't blame him. But it looks like we're going to be here all day. This is vital. You're a self-blamer. Okay. More sidebars than the Playboy mentioned. Not as many as yesterday so far. This is actually tame. We've got a record of 13 in one day. We didn't come close to it. Well, we came close to it yesterday. I think we're at 9 or 10 when they finally called it. We thought we were going to beat the record, but we didn't. And today's been much slower. This just, I don't even know what to say anymore. This is going on and on. Like they're both, both Brennan and Alessi with this witness. It's just a bit of a circle around. Hmm. I am looking forward to the lunch break though in 15 minutes. I need a good stretch. Need some fresh air. Make some more coffee. I think the jury could use a break themselves. Rocky Cop says she can't be. You guys. Hmm. She does have a wealth of knowledge and she does believe herself to be an expert here. So, yeah, I need a whole nother pot, Maggie. I hear you on that one. Do you think Alessi's complaining about my Hank Brennan doing objections? Your Honor, no object. He's doing too many objections after all of the ones they were doing. Mm-hmm. Mm. Hmm. I just don't know where he's going with this one. I mean, it's all just confirmation, I would believe. Hmm. Oh. Mm-hmm. I see. So I would have said it was my fault because I had left the party without him. But I could celebrated my 41st anniversary. I am not sure what that's in regards to. It looks like a different conversation. Sorry. I don't know. Yep. Oh, remember Dr. Curry, Liam? Boy, was she an expert psychologist as a counter to Dr. Hughes, who's actually Dr. Dawn Hughes is actually testifying for the government in the P. Diddy case. Well, she wasn't allowed to do a diagnosis or anything. She was only allowed to talk about the research she's done in the common factors of why women don't leave, the financial constraints, the PTSD, generalized. She wasn't allowed to subscribe it to anyone as an expert witness. That woman has testified in so many cases. Liam, do you follow Dr. Curry on TikTok? Or on Instagram? I meant Instagram, not TikTok. I don't even use TikTok anymore. I deleted the app. Okay, we're back. That was a long sidebar.
May I have a moment, Your Honor?
Yes.
Thank you.
Rodent, that was Dr. Curry. That's who we're talking about.
Dr. Russell, do you recall questioning by Attorney Brennan with regard to some alleged clip with regard to a motor vehicle, the Lexus and the pedestrian in this case? Do you recall that discussion?
Yes.
And have you reviewed and Attorney Brennan asked you about the slide presentation, what Dr. Welcher did with regard to this supposed accident reconstruction? You remember those questions?
Yes.
Mr. Woke, if you could please publish the slide from Dr. Welcher's presentation with the arm out in the glass in the back, not that one, the one in this case of the Lexus and Dr. Welcher dressed up as Mr. O'Keefe and with the clothing in the back, but with his that would be toward the back of that slide presentation, probably around 130-ish, 120. That's it, yes. And what slide number is that? 109. So, Dr. Russell, can you see what is depicted on that slide?
Yes.
Is that impact that is depicted on this slide, is that a clip or is that a direct impact to the arm?
I believe that that's a rather direct impact.
Okay, so this is a direct impact. And now, from your experience, and you were asked about this on cross-examination, a direct impact to the arm, assume, as was discussed, a motor vehicle, 6,000-pound Lexus going 24 miles an hour in a reverse with a direct impact on the arm. From your experience as an emergency medicine physician, what type of injuries would you expect to this arm?
So I would expect at least significant bruising, at least. But I would also expect fracture, possible dislocation of portions of the arm.
What portions of the arm would you expect fractures and dislocations?
Well, from this image, if it impacted that section of the arm, and let me use my pointer, right here, a very good possibility that there would be a radius and ulnar fracture of the forearm or an elbow fracture.
Could you please stand up and with your Honor's permission, show where the radius and where the ulnar bones are of the arm? Lights on, please. Thank you. You can keep the lights on.
So the radius and ulnar are the two long bones in the forearm right underneath the skin. And then they join with the humerus bone here in the upper arm at the elbow. And those, of course, these bones are they're susceptible to fracture with a significant impact. And also the elbow would be susceptible to fracture.
How about the hand?
The hand could be injured. It depends on where the hand was in relation. And also, if there was a fall, there are other mechanisms that could contribute to a fracture from the actual fall onto the ground. So there could be a wrist fracture, digital fractures. It depends on the circumstances.
Thank you. And do you can be seated. Thank you very much, Dr. Russell. From a direct impact to the arm, as you said, is depicted here. What is the likelihood of there being any fracture to any bone?
Yes.
Sustained in that form.
Do you have an opinion based upon a reasonable degree of medical certainty as to whether there would be any fracture to any bone?
I believe that there was a very high likelihood that there would either be a significant bruise or a laceration or a fracture of the bones.
Now let's go to, as I understand it, you have reviewed the autopsy report of Mr. O'Keefe,
Yes,
and you've reviewed the file, the medical records files, correct?
yes.
Is there any indication at all of significant bruising to the right arm of Mr. O'Keefe?
No.
With regard to the lower extremities, from what is depicted here, meaning this impact, did you evaluate the autopsy and the medical records to see what evaluation was done of the lower extremities?
Yes, a very extensive evaluation of lower extremities was done.
What very extensive evaluation was done and by whom?
By Dr. Scotabello, and it was both an external and an internal examination of the lower extremities.
Let's start with the internal examination by Dr. Scotabello. Could you please describe what type of internal examination she performed?
Well, she opened up the legs.
Sustained.
May we approach her for lunch?
All right, jurors, I'm going to send you out for lunch, okay? We'll see you at 2. Yes, come on up.
That's that. Glancing. Oh, gosh. Isn't the prosecution's theory that it has a glancing theory, a glancing blow? Yep. I don't know. Because he's the defense and he's not going to agree with them no matter what. Okay, yeah, so. I think we're going to lunch now, right? Yeah. Well, no, here we're back. Wait. Sidebar. Over. That was sidebar number. God, that was 6? No. Yeah. Oh my gosh, I gotta go back now again. I've got to mark my little stick thing on the last one. Just want to make sure what Rocket and I agreed on. That was 5, so this is 6. So I am caught up. Okay. I think we're going to be going to lunch after this. It is exactly 1 minute to 1. What are the chances, right? I'll bet you guys a nickel we come out of sidebar and go to lunch. Right? I think it is a good time for a break when we come out of sidebar. Let's take our lunch. Hopefully, Dr. Judge Cannone agrees with us and gives the jury a break. They've got to be like resting their heads in their laps by now. No, she's not, Teresa. She made bail, and she made bail right away, actually. She was never. No. She's not locked up. Yeah, I saw that. She's not been very responsive. You're talking about Karen Reed, right, Liam? She did. She's not been very reactionary to anything that gets put into for the evidence. I hope they are discussing lunch and go to lunch. It should be a short discussion, but I think it's more about like how long this is going to actually go. They're definitely muddying the waters, and that's their job, remember. The defense, reasonable doubt. That's what they're going to build. I'm curious to see what's going to happen with this missing witness in jury instruction. They're really annoyed the Commonwealth didn't call Proctor or Albert or Higgins. Mhm. It has been years since the event. Did she send them to lunch? Because they're on sidebar, Maggie. Did she? I must have missed it. Did she actually say that? Yeah, she was. I wonder, Liam, everyone actually, not just Liam, but I do wonder what the jury thinks of some of Karen's reactions in the court or lack of reactions, especially to some of the most emotional testimonies. There is a lot happening today. I missed it, but often when she talks so fast like that, I miss exactly what she said. I'm just like, and I couldn't get my mic off. Like, I've been, so my mic button keeps sticking today. They're back. We're going to find out now.
All right, Chrissy, does that help?
All right.
She did dismiss them for lunch already before they went to sidebar. I would imagine we're out for the hour then. I will see everybody back on the next stream, but we all could use a good break, yes? I do believe we could all use a good break for lunch, and then we will be back. Let me just get the second stream up for you guys that are on YouTube. If you are watching from the Twitch side or on X, it will just appear again like it did. If you're on Twitch, it just appears right where you are. You don't have to worry about it. YouTube, you're going to have to go to the next stream because this one will end and so will the chat. So for YouTube, this is the next stream for YouTube. And it will start a little before 2 o'clock when they're due to be back. Right? She said an hour. I would imagine she said an hour, right? But I will keep the feed up just in case, and I will definitely be ready if it goes live. This is true, Liam. That's very important. We don't have to like her. Justice is not about whether she's likable or what we think of her or whether she's a good person. It's not about whether or not she's a good person, right? It's whether or not they can prove she did the crime. Thanks for the reminder. All right, everybody. I'm looking forward for a little air, so I will see you all shortly. Have a good one. And I'll see you all hopefully in the next stream. Thanks, everybody, for joining me. And for those following you later, don't forget to like, share, and subscribe. And if you have any questions about this trial or any of the other cases that I'm following, please hit the comment section. I do enjoy hearing from you all. All right, I shall be back.